4 sir. $51 days sir. ಹಾಕಿದ್ದಾರೆ. Here to release of amount. ಆಯ್ತಲ್ಲ ಗಿರೀಶ್? ಆಯ್ತಾನಪ್ಪ.
ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದೀನಿ ಇಲ್ಲಿ ನೋಡಿ, ಇಲ್ಲಿ 14 ಲಕ್ಷ ಲೈಬಿಲಿಟಿ ಅಂತ ಹೇಳಿದೀನಿ. ಇನ್ನು ಏನಿಲ್ಲ. ಯಾರು ಹೇಳಕ್ಕೆ ಒಳ್ಳೆ ಚೆನ್ನಾಗಿದೆ. ನಮ್ ತಾನೇ ಅಪೀಲ್ ಏನು ಮಾಡಿಲ್ಲ. ಇವಾಗ 28,92,000 ಅವಾರ್ಡ್, 92,256. ನಾನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇರೋ ಅಮೌಂಟ್ 14,44,000, 14,46,128. ನಾನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇವ್ಯಾಲ್ಯೂಯೇಷನ್ ಅಷ್ಟೇ. ಇವ್ರು ಬಾಯಿ ಬಂದಂತ ಬರೀತಾರೆ. ಹೇಳಿ
ರಿಪೋರ್ಟ್ ಆಗುತ್ತೆ.
ಸಾಹೇಬ್ರು ಹೇಳಾಯ್ತು, ನಿಮಗೂ ಹೇಳಾಗಿತ್ತು. ಇದೇನು ವಾರಂಟಿ ಅದಕ್ಕೆ? Day before yesterday, I requested Malad get one matter posted. It is not
Fresh matter,
fresh alla. Stay illa, ಅದಕ್ಕೋಸ್ಕರ I am suffering warrant. 5 times I have moved.
ಅಲ್ಲ ಇದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ಇದಾರಾ?
ಇರ್ಬೇಕು.
ಆಯ್ತು 235. ಅದ್ಯಾಕೆ ಮನೆ ಕೊಟ್ಟಿದ್ದು ನಮ್ಮ ಯಾಕೆ ಬರ್ಲಿ? ಎಸ್ ಸರಿ.
Page number 1, serial number 1 to 8. Page number 2, serial number 9 to 15. Page number 3, serial number 16 to 19. Page number 4, serial number 20 to 24. Page number 5, serial number 25 to 30. Page number 6, serial number 31 to 39. Page number 7, serial number 40 to 48. Page number 8, serial number 49 to 58.
52. Yes.
Mohan A.
Yeah, the trial court is hearing the matter today, yesterday and today. Your lordship may kindly put this matter after reopening.
Yes. Leave this matter. Fourth January. Yes. Have you informed the other side? This is moved matter last day, Mr. You informed and come. Otherwise, when the matter is reached, you. ಅವ್ರು ಬರ್ದೇ ಇಲ್ದಿದ್ರೆ ಒಳ್ಳೇದು. ಅವ್ರು ಒಪ್ಕೊಂಡ್ರೆ ಬೇಕಾದ್ರೆ I will urgent now in 2 months. But last day when they have moved that matter, there may be some urgency. You wait with the matter is list. Called. Yes.
Page number 9, serial number 59 and 60. Page number 1 regarding office objection, first time matter, serial number 1, yes, Raju for appellant.
Yes. Paso, you comply office objection. Yes.
Serial number 2, Ravi Santati.
Glad I appear for the appellant. ಇದರಲ್ಲಿ valuation I have stated correct. The amount under dispute is only 14,46,128. I have stated that. But in spite of that, the office has raised the objection.
Value of appeal is stated correctly.
The total award is 28,92,256. The dispute is only with regard to 14,46,128.
Why you are disputing only that
50% we are admitting.
other 50% you are challenging?
50%
Yes. Submission of learned counsel for the appellant in respect of office objection is accepted. Office objection is overruled.
Case of death, my lord.
Yes.
Parents are claimants.
Yes.
Instead of 50% deduction, 1/3 is deducted towards personal expense.
1/3.
The only point.
Yes. Heard. Issue notice. Stay up. Judgment and award dated 21st August 2023, passed by Additional Senior Civil Judge MSCT Srirangpatna. He stayed passed in MEC 2282 of 2019, subject to deposit of 50% of the award amount with interest before the tribunal.
Serial number 3, Siddharamaya.
2 weeks time is granted to comply that of subjection.
Serial number 4, Padmavati.
For the appellant. Simple, my lords,
What is that of subjection?
objection is that, my lord, respond number 1. Husband's name to be corrected, my lord. There is some spelling mistake, my lord, that I can do.
Minor details to be correctly stated in the
That, my lord, represented by minors, my lord, I can do it, my lord.
What is that minors this thing?
Seal of picture. ಅದರಲ್ಲಿ
Seal ಬಿಡಿ minors ಏನು details?
claimant is the claimant
You
number 2
correct
is
it.
minor ಅಂತ ಮಾಡಿ.
Password.
I will do it.
Serial number 5, Janardhan Reddy for appellant.
For appellant, my lord.
Hmm.
Officer, court fee.
You have paid the court fee. That is the only office of the Learned Counsel for appellant has produced that
The morning we have paid.
voucher to show that he has paid the court fee. Office to verify and proceed for the rest.
Insurance company challenge liability, my lord. As an data for there is no deal.
No dear.
Please, my lord.
Delay idea?
Delay is
Huh? Is there any delay?
Please, my lord.
Yes. How issue notice day of judgment and award dated 11th October 2023 passed by NACT Bangalore in MEC 3856 of 2022, subject to deposit of entire compensation amount with interest before the tribunal within 4 weeks.
Serial number 6, T.S. Venkata Subbarav.
What is the tough subjection?
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಬಂದಿದೆ
ಹ್ಮ್.
ಮತ್ತೆ ಡಿಲೇ ಬರೋದಿಲ್ಲ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ
Okay, pass on.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
Second time office objection matter, serial number 7, Shri Shankar Reddy for appellant. M.
But
Babu.
I complied with all of the office objections,
Hmm.
except one office objection which has been raised,
Hmm.
that I have to serve copies on the learned advocate appearing for the caveat.
Hmm.
Yesterday, my lord, we went to his office. He said that he has not filed caveat. We came back here and checked the, my lord, whatever is the, email ID that was furnished and the phone number that was furnished.
Hmm.
To that address, my lord, we have sent it and filed an acknowledgement.
No, he said he has not filed in a caveat.
ಅವ್ರು ಹೋಗ್ದಾಗ ನಾವು ಹಾಕಿಲ್ಲ, ನಾವು MBC ಸೈಡ್ ಮಾತ್ರ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದು, ಸಿವಿಲ್ ಸೈಡ್ ಅಲ್ಲಿ ನಾವು ಕೇವೇಟ್ ಹಾಕಿಲ್ಲ.
ಯಾರ್ದು ಇದು ಮತ್ತೆ? M. Babu. Where is that office, Mr.?
ಕಿಲಾರಿ ರೋಡ್
Hillary Road. Yes, same.
ಸೇಮ್ ಆಫೀಸ್ ಹೋಗಿ ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿ ಇಲ್ಲಿದೆ ನೋಡಿ ನಿಮ್ದು ಕೇವೇಟ್ ಅಂತ ಹೇಳಿದ್ರೇನು ಕೂಡ ನಾವು ಯಾವ್ದು ಸಿವಿಲ್ ಸೈಡ್ ಅಲ್ಲಿ ಹಾಕಲ್ಲ, ನಾವು ಬರೀ MBC ಸೈಡ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದು.
And Babu, he has signed and it is in respect of.
ಅದೇ ಅಡ್ರೆಸ್ ಗೆ ಆಮೇಲೆ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಕಳ್ಸಿದೀವಿ, ಆಮೇಲೆ ಇಮೇಲ್ ID ಏನ್ ಕೊಟ್ಟಿದಾರೋ ಅದಕ್ಕೆ ಇಮೇಲ್ ಕೂಡ ಮಾಡಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಹಾಕಿದ್ವಿ.
Yes, Learned Counsel for, that is the only office objection.
That's the only office objection.
Submitted that. The caveat copy has been sent to that caveator through WhatsApp
And email.
and email. None appear for, anyhow that his name has been shown, he has not appeared.
ಹೌದು.
Yes.
ಇದಕ್ಕೆ
None appear for the caveator. Yes.
injunction suit has been filed not with respect to
Yes.
sites.
Yes.
With respect to a site not that has been allotted to the share of the plaintiff. Your lordship would.
Suit for?
Suit is for the relief of permanent injunction.
Yes.
Not your lordship would also notice that serial number
You are the
9.
plaintiff or a defendant?
I am for the plaintiff, not.
You are the
Serial-
plaintiff.
This
Yes.
is connected with not serial number 9, 10 and 11.
Why
Which are
three?
listed. All of them not are brothers who have been allotted certain sites not in the same registered partition deed. In terms of the partition deed, my lord, they have got the revenue records transferred to their name. When my lord, other family members my lord, try to interfere, we file a suit for permanent injunction, my lord, restricting those sites which have been allotted to the share of each of the parties. Trial court, my lord, in the first instance, was pleased to grant an order of status quo that was continued from time to time. And by virtue of the impugned order, my lord, status quo order has been vacated.
No, now that defendants are your family members.
Other family members, my lord, who have already been divided earlier.
Yes, they are interfering into that.
Please, ma'am. There was an order of
Yes.
status quo throughout, my lord.
Issue notice. Parties are directed to maintain status quo in respect of suit scheduled property till next date of hearing.
It is connected with serial number 9, 10 and 11. Sir
Same.
brothers,
Same.
please.
Yes, same order. ಅದರಲ್ಲೂ ಕೂಡ ಸೇಮ್ ಕೇವೇಟರ್ ಅಲ್ಲ?
Same caveat, ಎಲ್ಲರೂ ಒಬ್ಬರೇ.
ಕೇವೇಟರ್ ಸೇಮ್ ಆರ್ಡರ್ ಬರ್ತೀನಿ.
Serial number 8, Shankar Reddy for appellant.
So, Lordship, these objections are compelled to only the pagination that will be done, I will do it.
ಹಾಂ ಸರ್.
So, Lordship, as far as the appeal is concerned, the insurance company appears questioning the
No, you
liability.
complaint, I will come back. Yes.
Serial number 12, M. Subbareddy for appellant, M. Sundara Raman.
I request this matter in order. The judgment I have to place before the court because I requested the BBMP council put in and read it. There's a point of law involved.
My lord, a request for a parcel, madam. Emails held up in court on number.
No, that you said BBMP,
My lords pointed out that there are.
no, that BBMP has issued notice him to stop that construction.
That is what I heard. We have no physical information. I'll place that also. The point of law involved.
Second,
My lord,
Second.
my lord, kindly pass on, my lord. Senior is coming.
They
End
also
up in
haven't
court
found the
also, my lord.
judgment. Morning we
Accurate.
called their office. Our
Yes.
judgment single.
yes, pass on. Yes. No, you are, in the meantime, we verify, is there any direction? If there is any direction, then there is no purpose of this.
Absolutely.
Yes.
Friend, my lord, pertains to issuance of successor certificate, my lord.
Yes.
The respondent had paid before the trial court rupees 39,000.
Hmm.
After completion of the drama, then I have made it, I have also paid the same amount.
Where is that,
39,000. I have filed a memo to that effect, my lords, on 27th June 2023.
so court fee has been paid under which provision?
ಅದನ್ನ ಅಲ್ಲಿ ಕೆಳಗಡೆ ಮೆನ್ಷನ್ ಮಾಡಲಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
No, under which provision you have to pay that? Is it not a market value?
ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಮೇಲೆ ಅವ್ರು ಕಟ್ಟಿರೋದು 39,000. 39,000 ಕಟ್ಟಿದ್ದಾರೆ ಅವರು.
39,000.
ಹೌದು.
ನೀವು ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಿ?
ನಾನು 39,000 ಕಟ್ಟಿದ್ದೀನಿ.
What is that property?
Property is a house, site property.
The
Our
client
mem-
and the appellant said that court fee of 39,000 already the office honorable court acknowledgement having paid that amount. So what is that office objection? Value of the appeal to be stated, Mr. For
Value
the
of-
jurisdiction purpose. What is that value of the property?
ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ, ಬಟ್ ಇದು ರೆಕಾರ್ಡ್ಸ್ ನೋಡಿದಾಗ
Records ಪ್ರಕಾರ ಎಷ್ಟಿದೆ?
50 ಲಕ್ಷದ ಮೇಲೆ ಬರುತ್ತೆ.
Then is it go to the division bench? That is how that they have stated. You mention that valuation, then they will court will office will decide.
ಅದನ್ನು ಕೊಟ್ಟಿದ್ದೆ ಸ್ವಾಮಿ.
ನೀವು ಇದ್ರಲ್ಲಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ಬೇಕು. ಅಪೀಲ್ ಮೆಮೋದ. Yes. Lease this matter first week of January. That is, no, this is not for court fee. Jurisdiction purpose they have asked.
Yes, yes.
Yes.
For order, second number 14, HJ Anand upper appellant, second matter, Big Pradeep.
Yes, we.
Matter, my lord, notice issued to first forest. Some claim.
ಇದು ಯಾರ್ದು ನಿಮ್ದು ಅಪೀಲ? Issue Sharaj told, yes, notice issued to that respondent number 1, written with postal Shara, unclaimed. Hence, service of notice to R1 is held sufficient. What about that second matter? You have to, yes. 14.1 ali weeks time is granted to pay the process, issue notice to R2. Yes.
Number 15, Praveen Kumar for appellant, Jonathan Reddy.
Praveen Kumar, NOC written with accepting the Vakalat filed with the advocate for the appellant written with that office objection, original Vakalat. Yes. None appear, leave this matter of 2 weeks.
Serial number 16, this is the number of appellant, connected matter.
Yes, Mr. Awaiting TCR.
We have not issued any policy in respect of the offending vehicle anta. We have filed a memo. Nobody gives policy particular. The learned member of the tribunal holds that I have only filed memo denying the policy.
But you have not produced that. No, but anyhow that other side is not representing.
Yes,
Then matter has to be heard and this thing.
please.
Yes, heard. Admit. Admit agidya. Why awaiting TCR? Yes. Awaiting TCR.
Serial number 17, Jananath Arivaje for appellant.
Yes. What is that?
The officer objection is that to be deposited, the remaining amount of claim amount that has to be deposited for the trial court.
What is that urgency now?
The urgency is that arrest warrant has been issued.
Now you have paid that entire
I've paid,
amount.
my lord.
Entire amount of the interest portion of the award has been deposited before the trial court.
Move the trial court to pay, deposit the remaining amount of 28.
Yes, learned counsel for the appellant has filed a memo. Wait. Has filed a memo enclosing the channel for challan for payment of the remaining amount before the trial court office to verify and proceed further. Heard, issue notice, stay of order dated 2nd June 2022, passed by Senior Civil Judge JMFC Chikanaikanhalli in ECA number 1 of 2018. Yes.
Serial number 18, for appellant.
Yes.
I will be challenged by it.
Vehicle involved in the accident is a two-wheeler.
Gear
Two-wheeler gear is the RTO itself comes and reposes before the court. Our appeal material. Even if it is there that paid recovery agate.
Ultimate. No, that not pass or we will have it first week of January. Yes. What is the
Maybe they before the court, they are not able to execute the award.
no, he is seeking Passover. Last working day. He knows that, you knows that what will happen. We will have it up first January. If you are both of them is there, I could have decided. Yes. Please this matter first week of January.
Serial number 19, Karnataka for appellant.
Date of accident is 20/8/2014,
Hmm.
not 20/8/2017 as mentioned in the few 9 and award
Avala mistake ಆಗ್ತಾ ಬಿಡಿ. 2014
14.
accident. Yes. Submission of learned counsel for the appellant is accepted. Office objection is overruled. Issue notice. Yes.
Serial number 20, Tejas and for appellant. Padmaja VS.
Yes, Mr. Tejas. Ready? Other side is not there. Yes, memo. Learned counsel for the appellant has filed a memo seeking dispensation of notice to R1. Notice to R1 is dispensed. First week of January. 4th.
Serial number 21, Vijay for appellant, Badri Vishal.
Served as copy now. But it is only a state of page number, sorry, because all the content of the member of the same. All the agenda outside ಮಾಡಿದ ಮೇಲೆ ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಎಲ್ಲ page number same.
I will permit you to move in that vacation bench.
ಇಲ್ಲ, what is passed in July.
Then first week of January.
First week of January, then only the date, let the offer of it be heard.
Yes. No, no. He wants time.
But there are three opportunities to be made. Pertaining to annexation, entry and inference. Let that opportunity be heard.
That will be along with that on that day itself, it will be decided, Mr. On that application for admissions also.
Because
Is this matter?
Annexation, I have not removed anything, it's all the same. And I have given the first only is pertaining to the page number, all the content of the memorandum of first copy is.
No, he is saying that order has been passed when.
Like,
Ah.
15,
Then there is no urgency for another 1 week. That's what he is saying. Yes, leave this matter on 4th January. Yes.
Serial number 22, Shivakumar Patti for appellant.
Yes. Discrepancy in the name of the appellant. What is? ಯಾರ್ದು ಅಪಲೆಂಟ ಪೂರ್ವನ disturbance in the name of the appellant number 2 APROOVA APROOVA correct ಇದೆಯಲ್ಲ ಏನಿದೆ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ AP OOVA ಅಷ್ಟೇ ಇದೆಯಲ್ಲ ಅಲ್ರಿ APROOVA ನೀವು APROOVA ಬರ್ತಿದ್ದೀರಾ ಇನ್ನೇನಿದೆ No, I'm not saying that we are not correcting their name. In the appeal before the trial court, APRVOVA. Here also you have written APRVOVA. Award al bere idya. ಅದನ್ನ ಹೇಳಿ ಯಾವ್ದ್ರಲ್ಲಿ ಡಿಫ್ರೆನ್ಸ್ ಇದೆ ಅದನ್ನ ಯು ಹ್ಯಾವ್ ಟು ಪಾಯಿಂಟ್ ಔಟ್. ಅಪೂರ್ವ ದಟ್ ಈಸ್ ಕರೆಕ್ಟ್. ಎಲ್ಲಿದೆ ಅವಾರ್ಡ್? ಪೇಜ್ ನಂಬರ್ 22 APORVA. ಆಯ್ತು ರೀ, ನಿಮ್ಮ ಹೆಸರು ಏನು? ಮತ್ ನೀವ್ ಯಾಕ್ರಿ ಹಿಂಗ್ ಬರ್ದಿದ್ರ? You yourself has not corrected in that appeal memo, mister. ಅವ್ರದ್ ಬಿಡಿ, ನಿಮ್ಮ ಹೆಸರು ನೀವೇ ತಪ್ಪು, ನಿಮ್ಮ ಹೆಸರು ನೀವು ಕರೆಕ್ಟ್ ಬರ್ದು ಅಲ್ಲಿ ತಪ್ಪಾಗಿದೆ ಅಂತ ನೀವು ಹೇಳಬೇಕು. ನೀವೇ ತಪ್ಪು ಬರ್ತಿದ್ದೀರಲ್ಲ, ಯು ಕರೆಕ್ಟ್ ಇಟ್ ಮಿಸ್ಟರ್ ಪಾಸ್.
Serial number 23, but Ramachandra for appellant, Bhushani Kumar.
Yes. Objections. Now that objection raised on that PF to be furnished on IA 1 of 2023, one set up to be, what is that IA 1 of 2023?
State.
Huh?
In case that state.
ಆಯ್ತು, ಏನ್ ನೋಟಿಸ್ ಆಗಿತ್ತಾ ಮುಂಚೆ? You have to pay that process. Okay. Today is for ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ. ನೀವ್ ಹೆಂಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಿ? ನೋಟಿಸ್ ಆಗಿದ್ಯಾ? ನೋಟಿಸ್ ಆಗಿಲ್ಲ, ಪ್ರೋಸೆಸ್ ರಿಟರ್ನ್ ಆಗಿದೆ. ನೋಟಿಸ್ ಆಗಿದೆ, ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ ಅವರಿಗೆ. ಪ್ರೋಸೆಸ್ ಇಡ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ಡ್ ಆನ್ ದಟ್ PF to be furnished on IA. You have to comply that. Yes. On the meantime, serve a copy to her. No, is there any delay? You are appearing for the claimant.
Yes, my lord, she is a widow. And she has been injured, she has taken care of 2 children.
What is your ground, mister? Wait. I will. If I pass any adverse order, then you can make yes.
I filed the objection because there are, my son is suffering from epilepsy in a minor child, not.
No, you are owner.
I'm the owner of the apartment.
You don't have any policy.
No policy is there.
No policy is there. Your vehicle is involved in the accident.
So that I am disputing that.
What is the disputing?
Not
As it is filed against you.
the driver will not,
What is that award amount?
3 lakh 11,000 will not is the.
You deposit that amount. I will grant in. Yes, 50% I will permit it to withdraw that.
Not just before the fact.
He appeared, he filed statement.
Then
Examination of not done, blood and what, that is okay.
ಆಯ್ತು, anyhow that
50% confusion. Everything is not treated by me, that one.
you nobody will admit. ಎಲ್ಲರೂ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕನ್ಸಿಡರೇಷನ್ ಯಾಕೆ? ಅದನ್ನೇ 25% I will permit it to withdraw.
ಅಲ್ಲ, she
ಯಾಕಂದ್ರೆ that's a different thing on our side. Can you see? I disputed the accident itself, not I disputed the there is no policy. There is no policy, my lord. And the judgment of the court will COVID period.
ಯಾವ ಪೀರಿಯಡ್ ಅಲ್ಲಾರ ಆಗ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್, ನಿಮ್ ವೆಹಿಕಲ್ ಇನ್ವಾಲ್ಡ್ ಇನ್ ದಟ್ ಆಕ್ಸಿಡೆಂಟ್ ಇಸ್, ಹ್ಯಾವ್ ಯು ಫೈಲ್ಡ್ ಎನ್ ಅಬ್ಜೆಕ್ಷನ್ ದಟ್ ಯುವರ್ ವೆಹಿಕಲ್ ಇಸ್ ನಾಟ್ ಇನ್ವಾಲ್ಡ್? ವೇರ್ ಇಸ್ ದಟ್ ಯುವರ್ then why you have not appeared?
Some difficulty. My son is suffering from epilepsy. Minor child around even today he is under treatment from the court. I did not contact him again.
No, is it a case of injury?
Yes,
What is that on proceeding on 330 Temple Nagapur Circle or North South Circle? Two-wheeler at that time, first respond who is talking his mobile phone. There is no policy.
No policy.
Then normally he will deny that accident. Who will admit if there is no policy, mister? Opportunity will be.
Therefore, I am making the
See, even I am ready to send it back now itself. We'll give an opportunity by you have to pay some amount because ultimately it will held that you are liable. You have to pay, but still then we cannot suffer that person who has.
My request was paid that the matter be remanded. I have completed with the proceedings of the case before the.
No, subject to you have to pay that 25%.
50% of deposit.
That is also subject to that final decision of that tribunal.
she should survive.
That's a different thing. Not a question of survival.
Then I am.
She is employed. She is employed.
Yes.
She should survive.
Yes.
50%.
Is this matter first week of January? Yes.
Today is a picture there, my house is attached and.
Let him attach. No, you don't want. You don't want to save your house, mister. I am saying that 25% you have to pay, that you are not ready to do it.
I mean, let us subject to the result of the ballot.
Everything will be subject to the result only. Yes. Yes, you deposit 50, 25 will be permitted to withdraw.
No, subject to the result of the.
You are the only climate.
Yes, ma'am.
Yes, you will take notice for all 1 to 3.
Only 1 month.
Who are 2 and 3, mister? Hello. Who are, who is 2? Driver of your vehicle. You want to take notice to him? Or yes, yes. Learned Counsel for the appellant has filed a memo seeking dispensation of notice to R1. Notice to R1 is dispensed. So and so is appearing for. Nimdu R1 ಗೆ ಯಾಕೆ ತೋರಿಸಿದ್ದಾರೆ ನಿಮ್ದು? You are for R2 ಅಲ್ವಾ? ನಿಮ್ ಕ್ಲೈಂಟ್ ನೇಮ್ ಏನೇನು? ಪ್ರಭಾಕರ? Then ಅವರೇ R1. R2 ಗೆ dispensed. R1 ಗೆ so and so appear. There is a delay of, ಎಷ್ಟು ದಿನ delay ಇದೆ? Delay of so and so days is condoned. IA1 of 2023 is allowed. Yes. Heard issue notice. Heard stay of judgment and award dated 12th August 2020 passed by the MACT Bangalore in MEC 2155 of 2018 is stayed subject to condition. Appellant has to deposit 50% of the award amount with interest before this court. After deposit within 4 weeks, the registry is directed to release 25% of that amount. 50% ಅಂತಂದ್ರೆ 1.5 25%. Yes, office is directed to release 75,000 rupees in favor of climate. First respondent Srimati Lakshmi after due verification. The same is subject to result of this appeal.
Number 24, Narsimaya K for appellant, SD Narsimha Prasad.
Yes. Office note regarding discrepancy in the schedule A boundaries to the south trial. Yes. What is this office objection? No, first you answer about that office objection, then I will go to the. What is that office objection?
I have filed not ordinary.
No, have you seen that cost title, cost list? There is an office objection regarding the discrepancy in that scheduled interim order in the boundaries towards the north from the trial court to the plain copy. Where is that plain copy, Mr.? ಆಯ್ತು ನಿಮ್ದು.
So he must retain the property.
No, where is the plain? Like ನೀವು ಹೇಳ್ರಿ ಮಿಸ್ಟರ್. No, you show me that boundary in the plaint, mister. There is a discrepancy in the boundary in the plaint as well as IA. That is office objection. Application. Injunction. And no, you have amended that boundary. Where is your plaint, mister? IA copy same boundary there.
32 to 49.
There is same boundary in that IA also. There is no discrepancy that I see.
That's the office objection that has been raised.
But see that in that IA, same is there. Yes, what is your case, mister? Again case ಏನು ಹೇಳಿ?
Stage ಈಗ
Stage alla. What is the case, mister? You are a plaintiff for a defendant.
not yet posted for evidence still. So
What is that, mister? He is
the
a
pending
plaintiff.
is there.
This is a case where.
Pending is there.
Wait.
But
He
this is a
he
case
is a
where
plaintiff for a defendant.
I am the defendant.
You are the defendant.
I am the both
Plaintiff
defendant.
appeal.
Plaintiff's appeal.
Suit for.
Suit for declaration and injunction.
What is that IA file?
One Srinivas Murthy, who is the plaintiff number 1.
No, I will come to that. What is that application for?
Application for injunction has been rejected by the trial court.
No, that's not to
Not to
alienate.
alienate, not to encumber,
Ah,
not to create any third party interest.
Don't create third party interest.
No, I will just narrate the facts, please.
Hmm.
Your Lordship may kindly see, one Srinivas Murthy,
Hmm.
who is the plaintiff number one, he purchases the property on 13/10/1999. If the Lordship dates are relevant.
Srinivas Murthy.
On 13/10/1999, Srinivas Murthy purchases the property.
Yes.
Survey number 14/3, 1 acre, measuring 1 acre, 11 guttas. He gives this property in favor of his sister by name Srimati Shanta Lakshmi on 29/7/2004.
Yes.
This
Yes.
Shanta Lakshmi
Yes.
in turn gives the property in favor of her daughter by name Vijay Lakshmi on 28/11/2008. To this gift deed, the plaintiff number one was also a witness. Then this Vijay Lakshmi, she sells the property in favor of defendant 2 and 3 on 1/7/2021. On 18/11/2022, defendant 2 and 3 have sold the property in favor of fourth defendant, that is Mr. Prabhu. The case of the plaintiff is that.
No, is there any relationship between that plaintiff and the defendant 1, 2, and 3? They are not the relatives.
No, only first defendant is the sister's son of first plaintiff. First plaintiff, Srinivas Murthy's sister, is one.
Now they are seeking
Shanta Lakshmi.
Declaration regarding that.
That the gift deed executed by plaintiff number one in favor of his sister, and the subsequent gift deed by the sister in favor of her daughter.
On
are
what
all null and void.
What ground they are saying that?
They are saying that this gift was given only for the purpose of looking after the welfare of the first plaintiff. So she has in turn sold the property. In fact, the gift deed
No, that is, it's okay. Now that it is in your possession, is it a vacant
it's an agriculture.
agriculture land? You are going to alienate.
I cannot be.
That is what that prior they have sought. Don't alienate.
So far as that aspect, the alienate property or not, I made my submission. I'll ascertain and make my submission.
Till then, don't.
If I have it at 2:30, I'll make my submission.
Yes, 2:30, Mr.
Your lordship.
ಆಯ್ತು ಬಿಡಿ ನಾನೇ ನಿಮ್ ಬಗ್ಗೆ 2:30 yes 2:30 ಬನ್ನಿ
2004 gift.
yes
Page number 25, Srinivasa SP for appellant.
yes ಎಷ್ಟಿದೆ 19 accident, yes, that is the only office objection. Submission of learned counsel for the appellant in respect of office objection is overruled, accepted, and objection is overruled. Yes, it's a climate appeal for enhancement. Notice.
Number 26, Raghavendra S for appellant, VD Chandrasekhar.
Give it up.
Yes. Yes. Note below cost title with regarding to the deceased defendant number 1 before the trial court under LRs.
First defendant died during the pendency of the trial suit, my lord.
First defendant.
They have already, other defendants are the LRs.
LRs has been treated before the trial court
Yes,
itself.
yes, yes. In fact, the application filed by, which is, that also
Yes.
is mentioned.
Yes.
The defendants are the suit for partition, my lord. Defendants are before this honorable court.
Defendant appeal. Partition suit. Yes.
My lord, 19 items are there, my lord. It is the only ground that is before the court is that the plaintiff, the respondent, has released, executed a release deed, my lord, registered release date, 2005 itself, in which he has mentioned that no, he will not claim ancestral as well as self-acquired properties, my lord.
Who defendant?
The plaintiff, the respondent herein,
Plaintiff.
plaintiff, my lord. And for that, the consideration is the valuable property was given to him, my lord, around 5 acres, which is not in dispute, my lord. Now, the item number A and K is concerned, my lord, I am developing it, my lord. I am putting up some construction. Now, that is been, an application has been filed.
No, what is his defense regarding that release deed?
Release date, my lord, it is not challenged. He has not challenged the release date, my lord.
Page 35.
Yes, yes. Para 14.
Yes, read.
My lord, in that, page 3 can be seen, my lord. In page 3, my lord. In page 3 only. page 75, my lord.
Ink page?
Page 3, the last paragraph. my lord.
Ink page
Other-
3.
Um,
ಯಾವ್ದ್ರಲ್ಲಿ
Release date ಅಲ್ಲಿ.
No, you, where is that release?
Page 71, please. Next 30.
Page
In that,
71.
my lord,
Yes, yes.
the internal page number
Page
75, my lord. Relevant page number 75, my lord.
Yes.
ಅದರಲ್ಲಿ para 2, my lord.
ಆದಾಗ್ಯೂ.
ಆದಾಗ್ಯೂ ಆರ್ ಶ್ರೀನಿವಾಸ್ is the plaintiff, not respondent hearing. ಈ ಮೂಲಕ ದೃಢೀಕರಿಸುವುದೇನೆಂದರೆ ಇನ್ನು ಮುಂದೆ ನಿಮ್ಮಗಳ ಅಂದರೆ ನನ್ನ ತಂದೆ ವಿ ರಮಾನಂದ್ ಹಾಗೂ ತಮ್ಮಂದಿರಾದ ಚರಾಸ್ತಿಗಳಲ್ಲಾಗಲಿ ಅಥವಾ ಯಾವುದೇ ಪಿತ್ರಾರ್ಜಿತ ಸ್ವತ್ತುಗಳಲ್ಲಾಗಲಿ ಭಾಗಾಂಶ ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳನ್ನು ಅಥವಾ ಯಾವುದೇ ಅಧಿಕಾರವನ್ನು ನಾನಾಗಲಿ ಮತ್ತು ನನ್ನ ವಾರಸದ ಹೆಂಡತಿ ಮಕ್ಕಳನ್ನು ಕೇಳುವುದಿಲ್ಲ. This is the covenant, my lord.
Who has given this?
This is by the plaintiff.
Yes.
After this, my lord, filed a partition suit, which is actually not maintainable.
No, what is this defense regarding this release date? Has he mentioned anything?
He has not challenged this release date till date, my lord. It is not been cancelled.
Para 30.
And the contention that taken is it is been obtained by coercion.
Coercion of fraud.
No, my lord, the issue is, my lord, out of 19 items, A and K is concerned, my lord, I am doing some developmental activity. Lot of materials are lying down, my lord. So 39, 1 and 2 was moved. That is where I am before this honorable court. The only contention taken in that, my lord, annexure.
Is it, where is that property? It's in
Property is-
Bangalore.
Yes,
Bangalore.
It's in an open site.
Kalagatpura, my lord.
Open place.
It's a site.
Kalagatpura.
Yes. Now that you are constructing that,
Yes, my
have
lord.
you obtained the plan?
Yes, my lord. Everything
is
is
that?
there, my lord.
Plan and this thing.
Not produced before the trial. portal.
Wait. You show me that plan. Without that plan, I can't permit you to me. If you have taken a permission and the plan, show me, then I will see what that interim order can be granted.
ಆಯ್ತು, my lord. ನಾನು
First week.
ಇಲ್ಲ ಈಗಲೇ ಕೊಡ್ತೀನಿ, my lord, because lot of my materials are lying
No,
down.
that is,
Lord,
no, one
notwithstanding
thing,
that,
you can't construct without that plan. Sir.
yes,
You
yes.
produce the plan, then I will see what that interim order can be granted.
Before that, my lord, one submission, my lord. In page 84, the IA filed by them, my lord. Para 10. Third line. This is the IA filed. Schedule A and K properties by putting up construction of permanent nature. There is
Para?
every like para 10, my lord, 84.
Yes.
Third line, my lord. There is every likelihood that different number 2 to 4 claiming equity. Lord,
I thought.
no, my lord, only one thing, my lord. Kindly see the impugned order, my lord. Impugned order, para 13, my lords. I have filed a memo not claiming equity, my lord.
No, even then, by court order will not permit you to put up a construction without the plan. If you have a plan, then I can see that what the interim order can be granted. Otherwise, tomorrow BBMP cannot come and ask you where is the plan, because you say that court has directed me. That this thing will not permit it.
I will produce it today, sir. 2:30.
Pass over.
Please.
Bill number 27, Ashok Jain party for appellant.
What is that?
Maintainability of subjection. Now, this case, not initially, not the claim petition came to be allowed. Not granting not some of these 9,04,000 with 6% interest at page number 25. Page 25. Then the insurer not filed a miscellaneous. Was not restored and not the fresh trial was not commenced. After that, not the judgment, this not page 87. The petition came to be dismissed. In that, there was no order for recovery of the amount which we had already deposited because there was an execution petition. During the interregnum period, filing of miscellaneous, they had filed execution and the amount was, the entire amount was deposited. But after
File a review there and seek for an order for return. How can you file an appeal?
what happened thereafter? What
You want to
happened?
set aside this order.
Thereafter, what happened? We had filed execution petition. The execution petition came to be dismissed as not maintainable because there is no observation or direction by the tribunal that my lord, that there is no direction for refund of the amount.
ಅದಕ್ಕೆ ನೀವೊಂದು ರಿವ್ಯೂ ಹಾಕೊಂಡು ಕೇಳಿದ್ರೆ ಆಗೋಗಿರೋದು.
Therefore, my lord, we have filed this appeal to modify, my lord, the judgment and award to say that, my lord, I am entitled for refund or recovery of the amount.
You have to file an application for review. There is an error committed by that trial court while passing an order. You file a review and seek for that.
Not under section 144 of, my lord, of CPC,
Hmm.
when an order, my lord, is reversed, my lord, the natural corollary is that, my lord, the tribunal should have passed, my lord, for recovery of the
That
amount.
is an error to seek for a review.
But in appeal also, my lord.
Appeal, see, dismissal order 173 ali appeal is not maintainable.
The dismissal and
Dismissal ali, we can say that order is confirmed or it has to be set aside. You want to set aside this order.
no, my lord, I want.
Yes.
my lord,
Then
I am saying, my lord,
modification and all-
modification of the order.
Modification can be done by that very same judge by filing in a review. Not here.
I will,
If you
I will
want
look
to
at
keep
it.
it pending
Yes,
and file in a review there and
Look.
get it modified. Yes, leave this matter up for
first week of, my lord, sir.
second week. Yes.
28 Narasimhamurthy for appellants.
Correct, my lord. Page number.
Council submission with regarding the topic subjection.
Page number 18.
Hmm.
Big page 18.
Since that fresh copy
Complete mark.
marking. Yes.
Three lines mark ಮಾಡಿ.
Yes, what is this?
Yes, my
There is
lord.
no other office objection.
Suit for partition. and
Is there any
separate
delay?
portion. No delay.
Yes. What is this matter?
Suit for partition and separate portion.
Yes.
Against the defendant number 1 to 28.
You are plaintiff or a defendant?
Plaintiff supplement.
Yes. Suit for partition.
Suit for partition and separate.
Yes.
My lord, along with filed the application for our 39 1 and 2
Hmm.
for not to alienate.
Hmm.
Defendant number 1 to 14
Hmm.
sold the property item number 1 to 18
Hmm.
in favor of defendant number 15 to 28.
Hmm.
The
Why trial court reject that?
trial court reject, my lord, the order 39 good 3, they have not completed the order. My lord, the earlier filed this suit vacation bill. Already order is complete. The trial court has stated in order, my lord,
Hmm.
the order 39 good 4 to vacate the interim order.
Hmm.
The order 39 good 3 is complete.
Have you sent that copy?
Please, my lord.
Then why is that finding against you?
The trial, the already.
Before that, you have an export interim order.
Yes, ma'am.
Yes, heard issue notice. Respondents are directed, parties are directed not to create third party interest in respect of suit scheduled property till next year.
Defendant number 1 to 14 dispense, my lord.
ಯಾಕೆ ಅವ್ರ ಮೇಲೆ ಏನು ರಿಲೀಫ್ ಇಲ್ವಾ?
ಇಲ್ಲ, they are not filed the objection.
Yes,
1 to 14
1 to 14
dispense.
ಇನ್ಯಾರಿಗೆ ನೋಟಿಸ್?
15 to 28.
15 to 20 emergency notice.
Interrogatory application matter serial number 29 Nagaraja Hegde for appellant. This is Sitaram Rao.
An application for correction of the judgment. The operative portion of the judgment, my lord.
Now that in that appeal filed by that claimants, it has been enhanced. That has not been brought to my this thing. Yes.
Operative portion, my lord.
Yes. IA 1 of 2023 is filed for correction of. Let me tell you that.
ಮೇಡಮ್ ಕೊಟ್ಟಿದ್ದು ನಮ್ದಿಲ್ಲ.
Judgment and award dated 20th September 2023. In operative portions of the order in para 13. Fourth line. Instead of compensation amount rupees 4,55,000, it has to be corrected as
7,11,000.
7,11,000. Accordingly, office is directed to make that correction and issue fresh certified copy.
Acha.
IAS disposed of.
Sandeep Maya for appellant.
Yes.
Owner's appeal minutes.
Why Mr. Owner has filed an appeal?
The liability fastened on the owner, Milad.
ಯಾಕೆ ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಇರಲಿಲ್ವಾ?
ಇಲ್ಲ, there is no respondent insurance company.
ನೋಟಿಸ್ ಡಿಲೇ ಇದೆಯಲ್ಲ, ನೋಟಿಸ್ ತಾಳಿ.
Say
Execution. Then you have to deposit 50%. Yes, or issue notice.
maybe 30%. That's
Normally insurance company ಗೆ ನಾನು full ಹೇಳ್ತೀನಿ. Owners ಗೆ 50 ಹೇಳ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ. Yes.
agreement.
Yes. Issue notice. Stay up. Judgment and award dated MECT Pavgada in MEC 967 of 2020 dated 29/10/2022 subject to deposit of 50% of that award amount with interest before the tribunal within 4 weeks from today.
Serial number 31, Kavita HC for appellant.
Notice.
Serial number 32, Ashok and Patil for appellant.
Yes, on what ground partially you are challenged?
Your Lordship may kindly release the amount. We have questioned the negligence and quantum.
Yes.
50% is deposit.
It's a case of injury, na?
Injury case.
How?
ಎಷ್ಟು ಅಮೌಂಟ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ? What is that amount awarded?
50,39,522.
ಏನು what is the age of the claimant?
24 years.
24 years, huh? Among that together, 40% of the amount shall be. Now that 50 lakhs has been awarded.
Yes.
25 has been deposited.
But we have deposited 30 lakhs minutes, almost 29 lakhs, 45,000.
57,000.
Now we'll permit you to withdraw 15 lakhs.
Is wheelchair malad.
ಆಯ್ತು ಒಂದೇ ಸಾರಿ 15 ಲಕ್ಷ ಏನು ಖರ್ಚು ಮಾಡಲ್ಲ. Don't take that entire amount, mister. It should be required for our layer. She or he.
She
She's a
was doctor.
doctor.
2019.
Then we'll permit her to withdraw. They have
Yes,
responsibility.
yes,
They will not misuse that. ಇಲ್ಲ ಅಲ್ಲ tribunal.
40% minutes of
Before
amount
this court malad.
to be deposited minutes in any
ಅದು
national.
remaining ಏನಾರ succeed ಆದ್ರೆ
Yes. Now,
Easy.
out of this minute, out of the amount minute, the tribunal has.
40% ಡಿಪಾಸಿಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ. Now we are releasing only 50.
Yes.
ಅಕಸ್ಮಾತ್ ರಿಡ್ಯೂಸ್ ಆದ್ರೂ ಕೂಡ ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ can be.
Yes.
She is a doctor. She may not be misused that amount. She knows how to.
29 plus 1 lakh, 30 lakhs.
30 lakhs before court. Yes.
Before High Court or.
Yes. IA 3 of 2023 is filed for withdrawing that amount deposited by the appellant before this court by the claimant. Here is that affidavit. For the reason stated in the accompanying affidavit, IA 3 of 2023 is allowed. The claimant, Dr. S. Srividya, is permitted to withdraw that 50% of the amount deposited, permitted to withdraw that amount deposited by the claimant before this, appellant before this court. Registry is directed to release that amount in favor of the claimant, Dr. Sri,
Yeah.
Dr. S. Srividya, after due verification through digital payment. Yes.
Serial number 33, CRSI AK for appellant.
Notice.
Serial number 34, G Lakshmi Saw for appellant.
Lordship, appearing for appellant, Lordship.
Yes.
This is the appeal filed by the KSRT, challenging negligence and quantum, Lordship.
Yes. Notice.
Yes, Lordship. May I request for the interview?
Then you have to deposit the entire amount. Yes. Heard. Issue notice. Yeah. Judgment and award dated 5th April 2023 passed by MECT Mysore in MEC 1226 of 2021. Subject to condition depositing entire compensation amount with interest before this court within 4 weeks.
Satish Chandra for appellant.
Notice.
Serial number 36,
Set. Notice.
serial number 37, Vesraju, claimant.
Notice.
Serial number 38, East West, claimant.
Notice.
Serial number 39, East West, claimant.
Notice.
Serial number 40, East West,
Notice.
41, East West,
Notice.
42, Harish NR,
Yes.
Enhancement of
Claimants.
climate
Insurance company ilva?
insurance companies.
Yes. Notice.
43, Lingaraj HS for appellant.
Yes, Mr. Linda.
C report I can.
Hmm.
And 1/3 data
Out. Issue notice
delay.
stay of judgment and award dated 5th June 2023 passed by MECT Bangalore in MEC 1235 of 2020, subject to deposit the entire compensation amount with interest before this court within 4 weeks.
44 Rajshekar K.
Yes, Rajshekar,
Another appeal.
one or appeal.
Out.
Why? Insurance company.
As on the date of the accident, driver had no DL. Have produced exhibit R5.
ಏನ್ ಪೇನ್ ರಿಕವರಿ ಮಾಡಿದಾರಾ?
ಏನು ನನ್ನ ಮೇಲೆ ಲಯಬಿಲಿಟಿ ಫಿಕ್ಸ್ ಮಾಡಿ.
ವೈ
ಅದೇ DL ಇಲ್ಲ ಅನ್ನೋ.
ಅಲ್ಲ ಪೇನ್ ರಿಕವರಿ ಯಾಕೆ ಮಾಡಿಲ್ಲ ಅಂತ?
ಇಲ್ಲ ಮಾಡ್ಲೇ ಇಲ್ಲ. DL ಇಲ್ಲ ಅಂತ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡಿ.
Accident occurred due to rash and negligent riding of third respondent rider of motorcycle.
I have produced the exhibit R5.
Handed over that motorcycle to the third respondent who had no valid and effective driving license. For the petition of the respondent found answering their arguments. Mood matter 5%. Mood matter 5%.
But like that, 51,200.
Support of the argument. Directly to pay the compensation to recover it from the RC holder. At the same time, Honorable Court is also held that there is a violation of the term of policy. Not be held responsible to pay the compensation. In case in hand, material collected by the investigation officer clearly established that the vehicle without having license. You have not argued that even pay and recovery also. Where is that driving license?
Exhibit R5.
Why the tribunal has not considered? R5. Notarized copy of the driving license.
ನೋಡಕ್ಕೆ ಹೋಗ್ಲಿಲ್ಲ.
Clearly state that R3 respondent drove that vehicle without having the license to ride that vehicle. ಎಲ್ಲಿದೆ ಅದು ತೋರಿಸಿ?
R5
ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ?
ಇದೆ.
R5 ನಮ್ಮ ಹತ್ರ ಎಲ್ಲಿದೆ ಕೊಡ್ರಿ. ಆಯ್ತು ಕೊಡಿ. Who is driving that vehicle?
ಸಂತೋಷ್
ಕಾಣಿಸೋದಿಲ್ಲ ಅಲ್ರಿ? It was valid. ನೀವು ಇರ್ಲಿಲ್ವಾ? ಅಪಿಯರ್ ಆಗಿರ್ಲಿಲ್ವಾ?
ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದ್ದೀನಿ, ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಬಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ಲ ನೀವು.
ಇಲ್ಲ ಹೇಳಿದ್ದೀನಿ, ಅದನ್ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ.
Who has argued that there is no driving license?
ಕಂಟೆನ್ಷನ್ WS ಅಲ್ಲೂ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದೀನಿ. As on the date of the accident, I am riding the motorcycle.
Delay ಇದೆಯಾ?
Delay in 6 days.
Or issue notice. Stay of judgment and award dated. Has they filed any execution?
Also, execution
Stay of judgment and
88.
ಇನ್ನೊಂದು ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ?
ಅದನ್ನು ಹಾಕಿದ್ದೀನಿ 54, 51.
MEC 168 of 2020 subject to deposit of 50% of the award amount with interest before this court within 4 weeks.
Serial number 45 Sharat Rexona.
Yes,
Serial number 45 Sharat Rexona.
notice.
Serial number 46 Vishwanatha Shetty for appellant.
Appellants.
Yes.
Here one is for non-production of the certified copy. And the reason is that though the honorable arbitrator has already pronounced the order and a copy is provided to me.
IFR dispensation with the certified copies of the
Page number
card.
34. So ಸಾಹೇಬ್ರು separate sign ಮಾಡಿ ಕೊಡೋ ತನಕ ಅವ್ರು ಕೊಡಲ್ಲ. So this is supplied to us. ಆ ದಿನ ಏನ್ ಆರ್ಡರ್ ಆಗುತ್ತೆ ಸ್ವಲ್ಪ ಪ್ರೊಸೀಜರ್ ಪ್ರಕಾರ ನಮ್ಮ ಸೈನ್ ಅದರ್ ಸೈಡ್ ಸೈನ್.
Yes, what is this matter?
The matter pertains to a joint development agreement entered into between deceased appellant Narayan Reddy and the respondent number 1 concerned. Joint development agreement was entered on 24/3/2011. I am not, it is not in dispute between the parties. The appellant was owner to the extent of 3 acres 15 guntas of land consisting of 3 surrenders. The respondent has agreed to put up construction and the sharing between the parties. But that may not please us.
Yes.
But as for the joint development agreement, my lord.
You are the landlord.
I am the landlord. as per the joint development agreement, page number 24 will come in, sir. Page number 24. So I mean, for 24 in the 45, 42% I am entering. Respondent is number
40?
one, something page number 45.
45.
Clause 5, 5.2, 42% and 52%. For 58 and 42, it is specifically agreed. I am not in disputing. My lord, what happened, my lord? He has put up construction. While putting up construction, he has represented that he is putting up construction. As per the plan, around 2,55,126 feet. My lord, the landlord, he was also not so educated. You know how to put this. He represented that out of this 2,55,000, the entitlement of 42% to the landlord is 1,07,150. My lord, by saying so, my lord, I am also not disputing. I have produced the copy of that supplementary agreement, my lord, at page number 69. Very intellectually, for 1,07,152 square feet area, 84 plots he has assigned. So we ಉಳಿದಿರೋದೆಲ್ಲ ಅವರಿಗೆ ಅಂತ ಬರ್ಕೋಬೇಕು. In page number 76 ಅಲ್ಲಿ plots allocated last ಅಲ್ಲಿ sir.
ಆಯ್ತು, ನೀವು ಆರ್ಬಿಟ್ರೇಷನ್.
So ಇದೇನಾಗಿದೆ ಕೊನೆಗೆ actual construction made therein is that my lords please 3,89,534 square feet area he has constructed. But I am coming to know about the same. The landlord issued a notice calling upon the respondent in 2007. Respondent has sent a reply, okay, we will sit across the table and sets the map, but he did not. Then my lord, CMT was filed before this honorable court. That came to be allowed and the matter is referred to the honorable arbitrator. My lord, before this it seems, my lord, landlord has filed one arbitration application. ಇನ್ನೂ ಅಮ್ಯುನಿಟೀಸ್ ಆಗಿಲ್ಲ, ನನಗಿನ್ನೂ ಬರೋದಿದೆ. ಕೆಲವು ಅದರಲ್ಲೂ ಕೊಟ್ಟರೆ ಎಷ್ಟು ಗೊತ್ತ ಸರ್, 31,000 ಡೆಲಿವರಿ ಮಾಡಿದ್ದಾರೆ, 26 ಪ್ಲಾಟ್ಸ್. ಮಿಕ್ಕಿದ್ದು ಕೊಡಲಿಲ್ಲ, ಸ್ವಲ್ಪ ಕಂಡೀಷನ್ಸ್ ಇವೆ, ನಾವು ದುಡ್ಡು ಕೊಡೋದಿದೆ, ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ. ವಾಟ್ ಅಬೌಟ್ ಮೈ ಲಾರ್ಡ್, ಆರ್ಬಿಟ್ರೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ 389 ಕಟ್ಟಿರೋದು ಪ್ಲಸ್ ನನ್ 168 ಬರಬೇಕು ಅನ್ನೋದನ್ನ ರೆಫರೆನ್ಸ್ ಇರಲಿಲ್ಲ. ಸೊ ಈ ಪ್ರೊಡ್ಯೂಸ್ ದಿಸ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಕೊಡೋದಷ್ಟು ಯಾವುದು ಅದ್ರ ಪ್ರಕಾರ ಅವ್ರು ಮಾಡ್ಕೋಬಹುದು. Now when the matter has come before the honorable arbitrator, my lord, by that time, in fact, his entitlement of 2,25,759 already he has sold away. And ನಾನು arbitration application ಇಲ್ಲಿಂದ ರೆಫರೆನ್ಸ್ ಆಗಿ ಶುರು ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಅರ್ಜಿ ಆಗಿದೆ honorable arbitrator. So the arbitrator has taken a view. ಆ AA ನಲ್ಲಿ ಆರ್ಡರ್ ಇದ್ರ ಪ್ರಕಾರ ಯಾವುದು ಈ ಸಪ್ಲಿಮೆಂಟರಿ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಬಿಟ್ಟು ಅಂದ್ರೆ ನಮ್ದು ಬಿಟ್ಟು ಉಳಿದಿದ್ದವ್ರು ಮಾಡ್ಕೋಬಹುದು ಅಂತ ಆಗಿದ್ರೆ I cannot consider. My humble submission, my lord, a person you wanted to deprive of 56,452 square feet area of my share, my lord, which I am legally entitled. Now ಪೆಂಡಿಂಗ್ ಇರ್ಬೇಕಾದ್ರೆ 4 ಮಾರ್ಬಿಟ್ರು ಸ್ವಾಮಿ ಅವ್ರ ಪ್ಲಾಟ್ಸ್. ಅಲ್ಲಿ ತನಕ ನಾನು ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ ಮೇಲೆ ಮಾರದೇ ಇದ್ದವರು ನಾವು ದಿ ಆನರಬಲ್ ಆರ್ಬಿಟ್ರೇಟರ್ ಆನ್ ದಿ ಗ್ರೌಂಡ್ ದಟ್ ಅಲ್ಲಿ AA ನಲ್ಲಿ ಸಿವಿಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ. ಸೊ ನಾವು ಈಸ್ ಟ್ರೈಂಗ್ ಟು ಎಲಿಮಿನೇಟ್ ದಿ ರಿಮೈನಿಂಗ್ ಮೈ ಲಾರ್ಡ್. ಈ 4 ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಇನ್ನೊಂದು 50,000 ಉಳ್ಕೊಂಡಿದೆ, ಅದನ್ನು ಮಾರಕ್ಕೆ ಈಗ ಪ್ರಯತ್ನ. My application is on
37 ಅಲ್ಲಿ ಅಪೀಲ್ ಬರುತ್ತಾ? ಅಪೀಲ್ is filed under which provision?
My lord, appeal is filed 37+1 arbitration. 37+1 B. So on verification in the office one day.
Cutting of refusing preventive measures under section 9. So what is that order passed by that?
Order passed by the honorable arbitrator is at page number 34 comments. So ನಾನು ನಾಟ್ ಎಲಿಮಿನೇಟ್ ಕೇಳಿದ್ದೆ, ಮಾಡಕ್ಕಾಗಲ್ಲ, ಅಲ್ಲಿ AA ನಲ್ಲಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರ ಕಂಡೀಷನ್ ಪ್ರಕಾರ ಅಂದ್ರೆ
no, IA is allowed in part by restraining the defendant number 1.
No, that is by arbitration application ನಲ್ಲಿ. ಇಲ್ಲಿ ನಮ್ಮ ಇಲ್ಲಿ ತಮ್ಮನ್ನೇ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು.
Which is that order you are challenging now?
ಅಲ್ಲ, in the result IA is allowed in paragraph. ಓನರ್ಸ್ ಶೇರ್ ಅಂತ ನಮ್ಮ ಶೇರ್ ಅವ್ರು ಮಾರಬಾರ್ದು ಅಂತ.
No, what is that order you are challenging before?
ಸೇಮ್ ಆರ್ಡರ್, ನಮ್ಮ ಶೇರ್ ಮಾತ್ರ ಮಾರಬಾರ್ದು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿ ತೋರಿಸ್ರಿ?
ಮೈನಾರಿಟಿ ಲಾಸ್ಟ್ ಡೈರೆಕ್ಟ್ in the result IA is allowed in fact by restraining the respondent number one from alienating the ownership share of the property as allotted under supplementary agreement dated 21/10/2012 ಅಂತಾರೆ. ಅದರಲ್ಲೇ ನನಗೆ 56,000 ಕಡಿಮೆ ಬಂದಿರೋದ್ರಲ್ಲಿ ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಮಾರ್ಬೋದು ಅಂದ್ರೆ ಸೊ ಇಟ್ ವಿಲ್
ಎಲ್ಲಿದೆ ಮಿಕ್ಕಿದೆಲ್ಲ ಮಾರ್ಬೋದು ಅಂತ ಎಲ್ಲಿದೆ?
ಅದು ಮಾತ್ರ ಮಾರಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ.
ನೋ, ನಿಮಗೆ ರಿಸ್ಟ್ರೈನಿಂಗ್ ದಟ್ who is R1?
R1 is the developer.
Developer has been directed to restrain, not to alienate that owner share ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Ownership share ಅಂದ್ರೆ ಅವ್ರ ಪ್ರಕಾರ 21 my kindly pay use
See, if you are according to the supplementary, if you are saying that he is not entitled that also on
that is
you
my
have to
case.
file an application.
No, may make a submission. My application is my lord, I am entitled for remaining 56 and also whatever remained with him. For remaining 56 concerned, my lord, the honorable tribunal has to decide whether that construction of 3,89,000 suppressed by him.
No, see, this IA1 is filed by whom?
By me.
What is your IA?
My IA is under my IA is under section 7.
Where is your application?
Please, my application may kindly be perused at page number 77.
This is
Application
Venkateswamy Reddy is your client.
ಇದರಲ್ಲಿ
Now
my lord,
the-
please just peruse page number 80, my lord.
Now, what is the prior you have sought?
My lord, my prayer is
Stated in
that
the
for
accompanying
page
affidavit,
79, my lord.
claimant applicant above
And for the reason shown in the accompanying affidavit, the claimant supplements abandoned application that the honorable court may kindly be pleased to restrain the respondent number one from alienating or encumbering the scheduled property in favor of third parties, either by themselves or its GPA holders, henchman, support, agent, so on, so on, so on. My lord, the scheduled properties to this application is that the remaining 56,000 which I am entitled. And he has already sold his 2,25,000 share. ಇದು ನನಗೆ ಇಷ್ಟು ಉಳಿದಿರೋದು ಏನಿತ್ತು ಅದನ್ನು ಮಾರಬಾರ್ದು ಅಂತ ಅದು ನನ್ನ ಎಂಟೈಟ್ಮೆಂಟ್.
No, but supplementary agreement you have given up.
No, my lord, my humble submission to this honorable court is that my lord, 42% of 56,000 ನಾನು ಬಿಟ್ಬಿಡೋದು.
ಆಯ್ತ್ರಿ, supplementary agreement ಯಾಕೆ ಮಾಡ್ಕೊಟ್ರಿ ನೀವು?
My lord, it is not done, it is in 2012. Construction is subsequent. In 2012, my lord, his representation is that 2,55,000 ಕಟ್ತೀವಪ್ಪ ನಿನ್ ಶೇರ್. 1,07,000 ನನ್ನ ಶೇರ್ ನಾನು ಕೊಟ್ಟಿದ್ದಾರೆ, I am not disputed. ಇನ್ನು 56 ನಾನು ಬರ್ಬೇಕಾಗಿರೋದು 3,89,000 ಕಟ್ಟಿದ್ದಾರೆ. That 56, my lord, can anybody, even a common man, 56,000 ಅಂದ್ರೆ 1,07,000 plus ಇನ್ನೊಂದು 56,000 168 ಬರುತ್ತೆ. 56,000 square feet built up area of apartments. No common man also will agree to give it up, my lord. It is a fraudulent act. ಆಮೇಲೆ ಇವ್ರು ತಗೊಂಡಿದ್ದೆ 2017 ಇತ್ತು.
IA 2 of 2022
occupancy certificate 2017.
dispensation of certified copies of that order. Peruse that affidavit for the reason stated in that accompanying affidavit. Production of certified copies of order is dispensed for a period of 4 weeks. Heard learned counsel for the appellant on IA 1 of 2023. Peruse that affidavit filed along with that IA. Heard the learned counsel for the appellant on IA 1 of 2023. Heard issue notice. Heard on IA 1 of 2023. The respondent
Number one is
directed. Respondent number, all respondents, huh?
some one other respondents are other my family.
Yes, respondent number 1 is directed to, respondent number 1 is restrained from alienating the scheduled properties mentioned in schedule to that application till next date of hearing.
Much.
Yes.
Number 47, Virupaksha appears in appellant.
For the appellant.
Yeah.
Suit Malots filed by the respondent number 2 Malots seeking partition Malots was partly decreed Malots. Malots, however, Malots in the suit Malots was placed ex parte Malots and judgment and decree was passed in favor of the respondent number 2.
Yes.
Only when Malots the court commissioner was appointed Malots and spot inspection was conducted Malot. I came to know regarding Malot's the judgment and decree, and I filed Malot's miscellaneous petition.
Suit for?
Suit for partition Malot's was filed by respondent number 2 Malot's. It was partly decreed Malot's allotting share Malot's in A schedule and B schedule properties Malot. Malot's in the year 2021 Malot's when the court commissioner was appointed Malot's, and when he came to Malot's conduct a spot inspection Malot's, I noticed Malot's that the judgment and decree is passed Malot's. I filed miscellaneous petition Malot's in the year 2021 Malot. Since there was delay of 3 years Malot's, I also filed an application. The
What
learned-
are you doing all this day, mister? You are in a party to the degree.
Malot's notice was not served Malot's in the OS Malot. I was placed ex parte Malot's in the suit. In
What has
2020,
happened to that your miscellaneous petition?
Malot's miscellaneous Malot's, I had filed an application for condonation of delay Malot. The learned trial judge Malot's, without conducting any inquiry Malot's on my application and also in the miscellaneous petition Malot's, has rejected my application Malot's at page 16 Malot's. Only Malot's considering the application Malot's seeking condonation of delay Malot. The learned trial judge Malot's, I was not permitted Malot's even to lead my evidence Malot's in the miscellaneous petition. At para number 18, it Lordship kindly peruses Malot.
It is dismissed. Then
Malot's, now in view of the dismissal of the limitation application Malot's, my miscellaneous petition is also dismissed Malot. Now in the FTP proceedings Malot, the learned trial judge Malot's has brought both the properties Malot's to auction.
no, what has happened to this miscellaneous petition?
Now Malot's, by virtue of dismissal of my application, the miscellaneous petition is also dismissed.
You have not challenged that.
Malot's, that is under challenge Malot's before this honorable court.
No.
Now Malot's in the MF.
Now that why delay?
Malot's, Malot's delay Malot's,
What is-
right? Malot's right from Malot's 2021 Malot's, he is suffering Malot's.
Mister, you have placed an ex parte,
I was placed.
filed a miscellaneous petition. That is dismissed on delay.
Malot's, that is the.
Then you have not challenged. Last moment filing an application and condoning here. You are not interested. Yes. Notice. Yes.
48, where these for appellant, Janardhan Reddy,
Yes. Ready? Dismissed.
On the ground of that, actions submitted only on the alien part that. Yeah, period is before the court, below.
Sir, yes, will secure the record. Yes. Office is directed to secure original records from the tribunal. You have filed. Office is directed to delete the name of Janardhan Reddy and show the name of B. Pradeep. Yes.
serial number 49, Sheikh Ismail Zabibullah for appellant, M. Chor Prakash,
Yes.
And the last, David, on the last date appearing, the only point in this matter is in the miscellaneous, whether the notice has been served or not. And yesterday and day before yesterday, I verified personally the entire lower court records. There is an envelope, acknowledgement and postal receipt. Because I am not on a record to get that application, the certified copy. I asked my client to file his application in person. He has filed it. Today, the register has assured that he will give that copy. I can.
And that's why that what type?
I can no. Envelope.
Envelope page.
What
Envelope
is
copy.
this? What is this matter? Just recollect my memory. Yes.
Lord, this is the case wherein, my lord, you counsel for the,
Now, what is the suit for?
Suit for specific performance.
You are a plaintiff or a defendant?
I am plaintiff.
Yes. Suit for
Suit.
specific.
Yes, it is decreed, my lord. In the course of trial, ample of opportunity was given to the respondent.
Ex parte order has been passed.
And she did not turn up. And now in the miscellaneous, immediately after a few days of decree, she made an application, got all these certificate copies and filed miscellaneous. The miscellaneous also, she approached the court with a delay and other aspects saying that she was admitted to Jaydeva Hospital for ill health. All those things, she made a statement and also filed certain documents also to show that she was under treatment. Well, and I made an application in the RT whether such the patient was admitted or not. In
No, the delay in filing a miscellaneous has been condoned.
but there is no.
there is no delay, but her reason not to appear before that Amal citizen court in the original.
That will hear him. He has to convince me that why miscellaneous petition is bad. Yes.
Lord, can you see page number 64, my lord? Order dated 4/2/2015, page number 60. PW1 present,
64.
65, Harvatnal. PW1 present, counsel for D1 files IA 6 and order 17 rule 1 CPC praying to urgent. That is my counsel.
Yes.
adjourn the case, heard on IA 6, peruse IA 6 filed under Order 17, Rule 1 CPC. No ground is made out to adjourn the case for cross-examination of PW1. Hence, IA 6 is hereby rejected. PW1 prayer of Sri SS to defer cross-examination is rejected. Cross-examination of PW1 is taken as nil. Sri DSJ advocate closes plaintiff side and evidence of DW1 by next 18.
Yes.
But kindly see 18, this is important. 18/2/2015. Sri SS advocate, that is my previous counsel.
Yes.
Files memo of retirement with postal receipt, copy of notice, postal envelope. Sri SS is permitted to retire.
Yes.
D1, that is myself, absent. Evidence of D1 not reduced. Argument by next day, 18 in the 19.
Now, your case is that there is no notice has been sent to you.
First, my lord, court has not ascertained whether any notice is
Yes.
reached to me. That is number one. Number two, my lord, in all fairness, my lord, the court should have been issued, my lord, a notice to
No,
me.
there is no such provision, I think. Council has given a proper notice, brought to the notice of the client, I am going to retire. Then I don't think, ಎಲ್ಲಿದೆ ಅದು ಲಾಯರ್ ಇದು ತಗೊಂಡ್ಬಿಟ್ಟು ನಾನು ರಿಟೈರ್ಡ್ ಆಗ್ತೀನಿ ಅಂತ ತಕ್ಷಣ ಮತ್ತೆ ನಾವು ನೋಟಿಸ್ ಕೊಡೋದು. ನೋಟಿಸ್ ಕೊಡೋ ಉದ್ದೇಶನೇ he is going to retire. Has he received this notice?
ಇಲ್ಲ, ಅದು ಹಿಂದೆ ಇದೆ. ಹಿಂದೆ
By
ಪೋಸ್ಟಲ್ ಕವರ್ ಅದು ಫಸ್ಟ್ ಪೇಜ್ ಪೋಸ್ಟಲ್ ಕವರ್ ಹಿಂದೆ ಇದಿದೆ. ನೋ ಸಚ್ ನಂಬರ್, ಹೆನ್ಸ್
No such.
ರಿಟರ್ನ್ ಟು ಸೆಂಡರ್, ನೋ ಸಚ್ ಪರ್ಸನ್.
It is not intimated to the party.
Because the conduct, that's what I want to impress upon this honorable court for a moment. If that lower court records are secured, how she has changed the address from time to time in the same place? And a second thing.
No, see, if it is not communicated to the order, court should not permit the advocate to retire. That is wrong.
There are two aspects.
Then
One
it is that responsibilities of the advocate to see that notice has to be served because he has to be.
There are, in this case, there are two aspects. One is first instance, she has come and she has said she want to engage some other advocate with no objection, wakalat, she has taken entire file.
ಎಲ್ಲಿದೆ ಅದು?
ಅದನ್ನ produce ಮಾಡಕ್ಕೆ ಯಾಕಂದ್ರೆ I am not the advocate on record in the trial court.
Now, what is that urgency?
Lord, now order my miscellaneous has been dismissed.
Now, what is that? Has he filed any execution?
I
Nothing.
am not yet filed. I am not yet.
Then we'll have it, let him verify. This is only a thing, whether you have been communicated for retirement or not. If it is not there, then you have any case.
Yes,
One
that's all.
judgment of
No,
That is-
there are various judgment even.
If it
I
is
can-
communicated, then second thing.
Right.
First
let-
aspect
number
is
one, my lord.
taking no objection is one aspect which I have to place on record, I will show it. And second aspect is this address, how she has played with the courts, I will demonstrate.
No, if they have taken no objection, I don't think lawyer will issue a notice. No objection produce ಮಾಡಿ ರಿಟೈರ್ಡ್ ಆಗ್ತಾರೆ.
ಯಾಕಂದ್ರೆ
Anyhow that.
ಅಲ್ಲ, even their case is
ಅವ್ರ ಕಾಂಟ್ಯಾಕ್ಟ್ ಹಂಗಿದೆ ಅಂದ್ಬಿಟ್ಟು ಅದು ಲೋವರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಾನು ರೆಕಾರ್ಡ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ how she
It appears that lawyer may be communicated, she has not come to that witness box. By frustrating, he might have been retired. But there is a procedure that court has to follow.
that procedure,
Whatever may be that between that lawyers and
Yes.
that client.
that procedure the learned advocate has strictly followed. I can place all those records.
Yes.
but instead of technicalities to do substantial justice, my lord, in all fairness, one opportunity.
No. Fairness is there. Only you have,
Very honest
Fair-
and sincere to the court.
if
Lord,
you are.
file is with
You are-
advocate.
No, if the advocate has intimated that I am going to retire, till you have not taken a step, that means to say that you are dragging that matter.
ಅಲ್ಲ, as could be seen, my lord, from the order sheet.
See, we'll see. After seeing that records also, if you find that no notice has been served to you, then matter has to go. If it is notice is served, then court will think whether how much cost can be imposed and do it. It is all depending upon, if notice is served, you have not been, then we have to impose more cost to compensate. It is not to give it easily. If notice is not served, then court may see that yes, it is a loss
In
opportunity.
impugned order, my lord, even before miscellaneous court, nowhere, my lord, neither they have raised this issue that notices served to me. Never.
Now we can decide by securing the record.
In the miscellaneous, there are two paragraphs where evidence, I will read it, then I will leave to the humble court, the way and the conduct of this client, and also the way in which they has,
No, matter is very
notice.
simple.
notice.
Lawyer has been permitted to retire. Is it in accordance with law? Only you can see the trial court records. And
That's fine.
yes.
There are-
When do you want? 5th, 6th, or 2nd week of January.
Second week of January.
Not fifth, my lord, fifth.
5th January. Leave this matter on records ಬಂದಿದ್ಯಾ?
ಇಲ್ಲ, that's
Yes.
good, ಒಳ್ಳೆಯದು.
Yes. Office is directed to secure that original records post immediately after receipt of the records.
But entry order granted that day.
Interim order granted earlier is extended till next date of hearing.
Serial number 50, RBS for appellant, claimant.
Yes, notice.
Serial number 51, Rajshekar K for appellant,
ಏನಾಯ್ತು?
51, 44 connected matter.
40?
44,
44 ಏನಾಯ್ತು ರೀ?
stay as
Claimants appeal.
same, judgment
Oh,
and
that,
award, owner appeal.
Owner appeal. Heard issue notice. Day of judgment and award dated 26th August 2023. Passed by MACT Pandavra in MEC 167 of 2020, subject to deposit of 50% with interest before the tribunal within 4 weeks.
serial number 52, adjourned, serial number 53, M. Madhusudan Rao for appellant,
That's what is filed by the seeking for the relief of declaration and cancellation and also for possession. The plaintiff is the grandson of one suicide. Dependent number one, that who is apparent number one before your lordship. He is the son of Mr. Suicide. The property measures about 30 feet by 40 feet. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಟೂ ಸಪರೇಟ್ ಈಸ್ಟರ್ನ್ ಪೋರ್ಷನ್ ವೆಸ್ಟರ್ನ್ ಪೋರ್ಷನ್ ಅಂತ ಮಾಡಬೇಕು ಬಿಲ್ಡಿಂಗ್ಸ್ ಹ್ಯಾವ್ ಬಿನ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಈಸ್ಟರ್ನ್ ವೆಸ್ಟರ್ನ್ ಪೋರ್ಷನ್ ನಲ್ಲಿ plaintiff is residing and he is also receiving rents. He suppresses that fact before the court. He claims that there is a registered gift deed executed by the grandfather in his name in the year 2012 or 13, and that I have been in permissive possession of the respect of the suit schedule property which is the eastern portion. And the dependent number one is in permissive possession of the property. He is not located. That is the story that admittedly, there is another registered gift deed. There is a gift deed executed by the father himself in 2015 in favor of appellant. That is the dependent number one.
Yeah.
So my case is that I am in possession of the property pursuant to the gift deed. And earlier to that itself in 1998, the father had executed a power of attorney in my favor. And I am in possession of the property. Here what had happened, the plaintiff files an application for a temporary injunction restraining the dependent, number one. Dependent number two is the daughter, whose favor dependent number one has executed a gift deed.
Yes.
Restraining the dependents from alienating the properties and all. That trial court holds that I am in possession of the property. My possession will be protected. Admittedly, without in the pleading play of affidavit accompanying the application.
No, why your apprehension? Is there any records is in the name of the defendant for alienation?
Everything is in my name.
Then how can they alienate?
No, I am the dependent.
You are the
I
defendant.
am the dependent. My only grievance is, Lordship, can you see what has happened is, if at all if the court below had.
Defendants are hereby restrained to alienating that. That is then a reasonable order.
ನಾನು alienating ಮಾತ್ರ ಮಾಡಿದ್ರೆ ನಾನು ಅಪ್ಪಿದ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ.
ಮತ್ತೆ
Kindly see the remaining portion of the order.
mortgage lease.
Please. ಅದು ನಾವು ಬಾಡಿಗೆ ಕೊಟ್ಟು we are living on the basis of the rents. He is also he is suppressing the fact that in the adjacent portion he is living and the property is let out. And I have let out the property to the rents to the tenants. ಆ ರೆಂಟ್ ಲೀಸು ಮಾಡಕ್ಕಾಗದೆ ಇದ್ರೆ I can survive. Only I am restricting my appeal only in respect of that portion. Nothing else. Otherwise, I can't even survive. I can understand.
No, you want to only lease it out.
I want to only lease it out.
Yes.
These are rented. That's what I am submitting.
Yes. Heard issue notice. Day of order dated 26th October 2023, passed by 8th Additional City Civil and Session Judge, Bangalore, in OS number 1605 of 2023. Subject to condition that appellant is permitted only if bar rent that suit scheduled property till next date of hearing. Yes.
54, we know
Then I will take notice to the advocate appearing in the trial.
Usually emergent notice. Yes. Sometimes they may not appear.
I understand.
Then again that notice. Yes.
Prasad.
Yes. Hmm.
Other the claims.
Hmm.
Claims other have given.
Hmm.
3 cents.
Hmm.
4, 25 and 37.
Hmm.
So this is a temper.
Hmm.
GP holder.
Hmm.
By adding one more one, there are 11 page 14.
No, shoot for.
For a declaration and training.
Hmm.
Page 14, page 14.
Hmm. 14. Yes. Hmm.
The trend is concept.
Yes.
Payment we are doing. You know, I have to go. Please follow this rate, 425, 37, whichever has been given. And apart from these reasons, there is no GPA sale other side and tampering GPA added to number 22 on A. And has total competition. The same to the rest right? And the rest by zero to become number 1 and 2. Now, when they started construction in the month of January, I find this. But I came to know the campaign, and I got the police. Police intervened, was stopped for 2 days. Then in the month of March, I went to school. The court did not grant me injunction. And after receiving the notice, they have taken time 4 occasions. And by that time, they started construction. Then now even without foundation, they completed for so then they may send a property. Come on, what I want is, let them be status for me. Yeah.
No, let them construct, but not to create third party interest. Not to create third party interest.
ಅಲ್ಲ ಅದರೊಳಗೆ ಇನ್ನೂ ಅವ್ರ ಕಂಪ್ಲೀಟ್ ಮಾಡಲಿಲ್ಲ.
ಕಂಪ್ಲೀಟ್ ಅಂದ್ರೆ
ಮಚ್
ತಗೊಂಡಿರ್ತಾರೆ, ಇನ್ವೆಸ್ಟ್ ಮಾಡಿರ್ತಾರೆ, ಮೆಟೀರಿಯಲ್.
ಮಚ್ ಆಫ್ ಪ್ಲೇಸ್.
Yes. Or issue notice.
Not to alienate.
Yes. Respondent is directed not to alienate that suit scheduled property till next day.
Or create encumbrance also.
Directed the respondent not to create third party interest in respect of the suit scheduled property till next date of the. Yes.
Siddaramaiah.
Yes.
Number 56, Chandrasekhar Executive for appellant, ND Raghavendra.
Yes.
It is not a period. I have appeared for R4 and R5 prepared KV petition. This is a shoot filed by the plaintiff, shoot seeking for declaration. A stranger to file shoot before trial court. I have taken contention.
Now that you are arguing or you
No, sorry, I'm detail.
arguing is for him has an
detail of that. So many documents.
yes, Mr. January 1st week.
There is an agreement of sale which has been entered by the owners with the builder. Let them in out of status quo, let them not proceed because agreement of sale is there. If by on account of this particular order may not be allowed, which of my lord's implications they are going to deal with the property and again I need to be litigated. Till then, my lord, let them in out of it.
My lord, already prior to that filing of shoot, we have entered into agreement of sale with.
You do whatever prior to that. After that, till next date, don't do anything.
Don't do it. No, already after death of my grandfather, we already applied the Koti Kata before concerned Tahsildar. But before Tahsildar, my lord, they have taken contention in that. My grandfather name is Muntamanna. Similar, the plaintiff grandfather name is Muntamanna, but father, our appa hesaru Papanna, Muniappa, they have Papanna, they have taken contention. That aspect, the trial court clearly observed in my impute order, my lord.
No, I'm not hearing on merit. I have not opened the file. He's saying that not to do anything till next date of hearing. That means to say
that even though I'm ready to argue on merits itself.
ಅದನ್ನ ಮುಂಚೆನೇ ಹೇಳಿ ಮತ್ತೆ ಯಾಕೆ ನಾವು
ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
You have two options, Mr.
Yes, yes, my lord.
If you are ready to argue, argue, don't ask that time. Yes. Kodi.
Normal property, which is an agricultural land.
Food for,
For declaration.
Hmm.
For permanent, not
you are the plaintiff or a defendant?
I am the plaintiff.
Yes.
But, case of the plaintiff is that, my lord,
Hmm.
the property was belonging to his grandfather,
Hmm.
right, interstate, my lord.
Hmm.
Subsequently, it was, my lord, he as well as his father,
Hmm.
Chikkanjanappa, both were in joint possession, my lord.
Hmm.
Even his father, very interstate, my lord.
Hmm.
But now, the plaintiff, being the sole son, my lord, he's in possession of the property.
So what is the defense of the defendant?
Defense of the defendants is that, my lord, that they thoroughly deny the fact that, my lord, I am in no way concerned to the family of Chikkanjanappa.
Hmm.
And they say that they set up, their claim that their grandfather, their father-in-law, defendant number one's father-in-law
Hmm.
had acquired the property.
Hmm.
Not by virtue of, my lord, the khata being made out in the names of the family member,
Hmm.
they have become the owners of the property.
Now, how your properties, the kata has been entered there?
That is the crux of the issue.
No, when it has been entered?
Lord, the entry was happened, my lord, in the year 19,
Hmm.
Lord, the year 1973-74 itself.
Have you challenged that?
But my name is there, my
Hmm.
grandfather's name is there.
Hmm.
The same name belongs to the father-in-law of the defendant number one.
Where is that?
I have produced, my lord,
Kodi? No, he is claiming that that name is belongs to his father.
his father.
Hmm.
Lord, here is a case where, my lord, section 50 has to be invoked, 50 of the Indian
No,
Evidence
that-
Act in order to prove, my lord.
No, what is your father name? What is your name?
My lord, my name is
Who is
Kempanna.
Dodda Patalappa?
Dodda Patalappa.
Hmm.
And my lord, Munitamanna is my grandfather's name.
Yes.
Lord, subsequently, my lord, the continued, my lord, till, my lord, 2000,
2022-23 ನಿಮ್ಮ ಹೆಸರ ಇದೆಯಲ್ಲ? ಯಾವಾಗ ಸೂಟ್ ಹಾಕಿರೋದು?
2023. When the moment they entered into the sale agreement, we having no other alternative, we filed the suit for, my lord, declaration.
Hmm.
Now, their claim is that, my lord, no, that Dottamanna is none other than the father-in-law of first defendant.
Hmm.
My lord, by virtue of, my lord, succession, they
Why trial court has rejected?
only on the ground that, my lord, I have not
Hmm.
produced, my lord, any of the document to show that how the lineages.
No, as on the date of filing the suit, revenue record stands in whose name?
My lord, is the name of my grandfather.
Yes. Yes, mister, what is that?
Entirely, I have taken condition, kindly see that, prior to that, well, detail of return statement before trial, but I have taken condition, my lord.
Hmm.
My grandfather, that is first dependent father-in-law name is Muntamanna.
Hmm.
Our father ಹೆಸರು ಪಾಪಣ್ಣ, ಮುನಿಯಪ್ಪ. That effect I produced number of documents before trial court. Even though they are alleging that he is stranger, he has taken ಅವ್ರ ತಾತ ಹೆಸರು ಮುಂತಮ್ಮಣ್ಣ. But ಅವ್ರ ತಾತ, ಅವ್ರ ಅಪ್ಪ ಹೆಸರು ಬಂದು ಮುನಿಯಪ್ಪ. Sorry, ಪಾಪಣ್ಣ. Even though they have produced before the trial court observing the impugned my lord. Read the portion of the impugned.
No, now that.
My lord, that aspect, after death of my grandfather, the property is standing in the name of, by your side, we have not transferred the khata. My lord, originally, the property in question entire large extent, that is 6 acres 27 gutas. Out of that, my grandfather acquired the Shushu property and entire extent in the 1956.
Yeah.
Even though the trial court, the plaintiff, before trial court, they have not asked how to acquire the property, they have not stated in the pleadings or anywhere. They have not produced any document that aspect. I produced number of documents for trial court, my lord. The, suppose some document is there.
Yeah, you
My
show me
lord,
that document.
My lord,
As on the date of filing.
as on the date, later I come later, your honor.
You are in the possession of the property.
Yes, my lord, my grandfather name, that is Muntamanna, still my name is showing the RTC Act.
ಎಲ್ಲಿ ಯಾವ್ದಿತ್ತು?
ಅಲ್ಲ RTC, what about my landed same document, ನಮ್ಮ ತಾತ ಹೆಸರು ಇದೆ, ಅವ್ರ ಅಪ್ಪನ ಹೆಸರು ಇದೆ.
ನಿಮ್ ತಾತನ ಹೆಸರು ಏನು?
ಮುಂತಮ್ಮಣ್ಣನೇ. ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು, ಅವ್ರ ತಾತ ಹೆಸರು ಅದೇ, ಟೇಕಿಂಗ್ ಅಡ್ವಾಂಟೇಜ್ ಆಫ್ ದ ಸೇಮ್ ಸಿಮಿಲರ್ ನೇಮ್. They are taking, ಅವ್ರು ಆಮೇಲೆ
Who is Dodda Patalappa?
ಅದು ನಾವು ಸೇಲ್ ಮಾಡಿದ್ವಿ. That aspect I have produced the sale deed. Now out of 6 acres 17 gutas, sold retained the 22 gunta, that is subject matter of the social property. Remaining I sold the clearly mentioned in my return statement
Sold to
also.
whom?
One Dottapatalappa, that is what about RTC shown in the name of.
Doddapattalappa is not your Dodappa.
Yes. I sold the property in favor of Dottapatalappa in the 1968. 68.
Doddapattalappa is not your.
ಮುನಿತಮ್ಮಣ್ಣ ಕೆಳಗಡೆ ಇದೆ, RTC ಕೆಳಗಡೆ.
Hey, ಕೆಳಗಡೆ RTC 3-4 ಜನದ ಹೆಸರು ಇದೆ. In the possession.
ನಾನ್ ಕೊಟ್ಟಿರೋ document.
ನೀವು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಇವ್ರ ದೊಡ್ಡಪಟಾಲಪ್ಪ ಇದೆ, ಮುನಿತಮ್ಮಣ್ಣ.
ಮುನಿತಮ್ಮಣ್ಣ is my grandfather. 22 ಗುಂಟೆ ನಾವು ಉಳಿಸ್ಕೊಂಡಿದೀವಿ.
ಇಬ್ರು they are claiming that
ಮುನಿತಮ್ಮಣ್ಣ ಅದನ್ನೇ ಅದೊಂದು aspect. that aspect I produced the number of death certificate
both
ಕೊಟ್ಟಿದ್ದೀನಿ.
of them maintain status ಕೊಟ್ಟಿಲ್ಲ next step.
ಅಲ್ಲ maintain status ಕೊಂತ ಇಲ್ಲಿ ಖಾತೆ ಆಲ್ರೆಡಿ ಪೂರ್ತಿ that is come to later ಅಂತ ಹೇಳಿದ್ದು. We already filed appeal before RRT proceeding before Tahsildar my lord. That aspect I produced the number of document. That effect, that is my grandfather name is Munintamanna. At that time the plaintiff has raised objection before RRT dispute copy ಇದೆ. ಅವರ that earlier they have taken contention ಫಾರಂ ನಂಬರ್ 7A ಹಾಕಿದೀನಿ, ಅದನ್ನ ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಹಾಕಿ 7 ಹಾಕಿದೀನಿ ಅಂತ ಆರ್ಡರ್ ಹಾಕಿ ಅದೇ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದೀನಿ. ಆ ಸರ್ವೆ ನಂಬರ್ ದಾವಾ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ. ಇವೊಂದು ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ RRT ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ in meanwhile the taking ಇದು advantage of the similar name should filed before trial court. And one time
ಇದು ಮುನಿತಮ್ಮಣ್ಣ ಇದು ನಿಮ್ಮ ಮಾವನೋ ಇವರ ಅಪ್ಪ?
the trial court observed they have not produced any G3 before trial court. ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಟ್ರೀನೂ ಕೊಟ್ಟಲ್ಲ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ?
ಟ್ರಯಲ್ ಕ್ಲೀನ್ ಆಗಿ ಹೇಳಿದೆ ಸರ್. ಇದು ಪ್ಯಾರಾ ನಂಬರ್ ಪೇಜ್ ನಂಬರ್ 23 ಸರಿ 21 ಅಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 7 ಇಂದ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಪ್ಲೇಂಟಿಫ್ ಸೊ ಅದೆಲ್ಲ ನಮ್ದು ಹಾಕಿರೋದು. Yes, right over the shoot property so the Chikanjappa is
Para 7 you read para 7.
The advocate for the plaintiff has produced the records of right in respect of social property. It shows that Munintamanna has right over the property, Aadhaar card so and so. The Chikanjappa, his son or Tande Chikanjappa, who is the son of Munintamanna, the defendant have produced the sale deed pertaining to the year 1957. That is produced the sale deed in the and 1968. Originally we have purchased the 1957 and we have retained the 22 guntas is subject matter of the social property. The show the Munintamanna, who is the son of Muniyappa, ನಮ್ಮ ತಾತ ಹೆಸರು, purchased survey number 6 measuring 6 acres 17 guntas. They also show that Krishnappa, who is the son of, that is my father, that is the husband of the first dependent herein. Krishnappa, who is the son of Munintamanna, sold property survey number 16 in favor of Doddapattalappa, that is remaining extent of 5 acres chilli ತೋರಿಸ್ತಾ ಇರೋದು. He also produced the death certificate of Munintamanna and Krishnappa. There shows that Krishnappa is son of the Munintamanna, ನಮ್ಮ ತಂದೆ ಹೆಸರು. Munintamanna is the son of Muniyappa, that is my grandfather, ಅವರಪ್ಪ ಹೆಸರು. In this case, the relationship itself seriously disputed by the dependents. Now our relationship is dispute. In support of their contention, they have also produced documents so and so. The plaintiff has not produced genealogical to show that the names of one sister. But the dependent have produced the heirship certificate. The plaintiff has produced the recent document so and so. The reason after obtain the interim order, they have pay the taxes. Tax non ಕಟ್ಟಿದ್ರು ನನ್ನ ಹೆಸರು ಡಾಕ್ಯುಮೆಂಟ್ ನಮ್ಮ Munintamanna ನಮ್ಮ ತಾತ ಹೆಸರನ್ನು ಕೊಟ್ಟು ಅದನ್ನ ಎತ್ಕೊಂಡ್ ಬಂದು ಹಾಕಿದ್ದಾರೆ. ಕೈಲಿ ಅದನ್ನು ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ವಿ. 26/11/20 2 ದಿನ ಆರ್ಡರ್ ಮೊದಲೇ ತಂದು ಹಾಕ್ತಾರೆ ಅದನ್ನ. ಅವ್ರ ಟ್ಯಾಕ್ಸ್ ನಾವು ಯಾರು ಕಟ್ಟಿದ್ರು ಅವ್ರ ತಂದೆ ಹೆಸರಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಕಟ್ಕೊಡ್ತಾರೆ ಯಾರಾದ್ರಲ್ಲಿ.
Where is that genealogical tree show that these are all who are that?
It is a dispute, my lord, serious dispute, my lord. That aspect, the trial court observing the same, clearly rejected the prayer of.
Wow, what is that? It is a vacant land or?
22 guntas vacant lands. There is an agriculture land.
Now, what you are doing that agriculture land?
My lord, I am doing earlier planted eucalyptus presently.
You do it, you cultivate.
Yes, cultivate. Only 22 guntas since from ನಮ್ಮ ತಾತ ಹೆಸರು ಇದೆ. They are taking advantage of similar name. They have filed false suit before trial court. Even though I have taken contention in my return statement, the suit is not maintainable for simple reason that the plaintiff is not in possession of the suit property.
Produce that genealogical.
Please, my lord, my only submission before this on the court is that, my lord, now what they have read with regard to selling the property in the year 1956 and 64, my lord, the dispute was raised in RRTCR where, but the Tahsildar himself has held that it is not related to the suit schedule property.
It is in respect of some other properties.
That,
That
say,
is what the contention which they have taken even in the return statement. They go to an extent of even denying the fact that Tahsildar has wrongly entered those RTCs, but it was only related to survey number 6 is what.
no, that,
The return
see,
statement they have taken.
you produce that genealogy, what will happen another 2 weeks?
Yes.
But my only submission is that I have produced a document to show that they have entered into the sale agreement.
No, that you, whatever documents he wants to.
Even though I have not got Kata, so due to that reason,
Let him also produce that. What will happen
Yes.
till that first week of,
Let them not go with regard to my lord this sale agreement.
which sale agreement?
The sale agreement which they have entered with defendant number 11.
No, now he has already entered.
yes, already entered. He is also a main party. Depend number 11 will ಮಾಡಿದ್ದಾರೆ ಅವನು party ಮಾಡಿದ್ದಾರೆ.
ಖಾತೆ ಮಾಡಿಸ್ಕೊಂಡು ಇನ್ನೂ ಅವರ ಹೆಸರು ಖಾತೆ ಇಲ್ಲ because their contention is that their grandfather's name is Naragehalli Uditama.
Yes, yes.
No,
That itself
that
is
will be
disputed.
decided.
So
Now, what will happen with, see, now they have already entered an agreement.
let
Then,
there not be any sale deed to that effect because in the event if they
sale
get
deed ಮಾಡ್ಬೇಡಿ.
Sale deed ಮಾಡ್ಕೊಳ್ಳೋ ಇನ್ನ ನಮ್ ಖಾತೆನೇ ಆಗಿಲ್ಲ. ಇವನ್ let him undertake that. ಅಲ್ಲಲ್ಲ ಖಾತಾ ಆಗೋದಕ್ಕೆ ನಮ್ದೇನು ಅಭ್ಯಂತರ ಏನಂತ ಹೇಳಿ ಅಲ್ಲಿ ಆಡಾಟೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ. ಅಲ್ಲಲ್ಲ let him ನಮ್ಮ ಹೆಸರು ಖಾತೆನೇ ಬಂದಿಲ್ಲ ಇನ್ನ.
No, that you are saying that you will not alienate that property.
ಏಲಿನೇಟ್ ಅಂದ್ರೆ ಅವ್ರ ಖಾತೆ ಆಡೋದಕ್ಕೆ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ರೆಡಿ ಟು ಅಂಡರ್ಟೇಕ್ ದಟ್.
ಅದು ಇದಕ್ಕೆಲ್ಲ ಸೇರ್ಸ್ಬೇಡ್ರಿ.
ಅಲ್ಲಲ್ಲ ಅವರು ಆರಾಟಿ ನಮ್ಮ ಹೆಸರು ಖಾತೆನೇ ಆಗಿಲ್ಲ. how can it alienate my lord?
Are you going to, I don't know that even without Tata can also alienate. We know that what is are going. Are you saying that you are not going to alienate or you want to alienate that?
I want already enter into an agreement, my lord. That aspect, my lord. That
Further, you want to give a sale deed or you wait till that filing an objection? Otherwise, I will pass an order not to create a sale deed in favor of that person.
I have still till next date I have not alienate, but in meanwhile I have already the already RRT dispute after remained due to that in the RRT dispute they clearly mentioned that OS number 716 stay ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು RRT dispute civil court ಅಷ್ಟೊತ್ತಿಗೆ ಆರ್ಡರ್ ತಗೊಂಡ್ ಬಂದಿಲ್ಲ ಹಾಕಿ RRT dispute ನಮ್ಮ ಹೆಸರು ಖಾತೆನೇ ಆಗಿಲ್ಲ. ಇವಾಗ ಆಲ್ರೆಡಿ ಅವ್ರು ರೆಡಿ ಅಪೀಲ್ ಕಡೆ ಹಾಕಿದ್ವಿ ಎಸಿ ಕೋರ್ಟ್ ರೆಡಿ ಟು ಫೈಲ್ ಅಪೀಲ್ ಬಿಫೋರ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆಲ್ರೆಡಿ ಇಂಟರ್ನ್ ಮಾಡಿ ವೆಕೇಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಅಪೀಲ್ ಹಾಕಿದ್ವಿ. ಬಟ್ ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ ಇವಾಗ ಖಾತೆನೇ ಆಗ್ತಾ ಇಲ್ಲ ನಮ್ಮ ಹೆಸರಿಗೆ ಆಫ್ಟರ್ ಡೆತ್ ಆಫ್ ಮೈ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್.
ನಾನೇನ್ ಮಾಡ್ಲಿ ಬಿಡಿ, ನಾನೇನ್
ಅಲ್ಲ ತಾವ್ ಮಾಡೋದಕ್ಕಲ್ಲ ಕ್ರಿಯೇಟೆಡ್ one stranger has paid, my lord. That aspect one stranger has paid shoot against me. How can they got entry ಮಾಡು? How can it ಅಲ್ಲ ನಾ ಕಣ್ಣು ಮುಚ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಕಾಗ ಯಾಕಂದ್ರೆ ಸ್ಟೇಜ್ ರಿಯಲಿ ಅವ್ರು ಆಗಿದ್ರೆ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕ್ಲಿಯರ್ಲಿ ಅಬ್ಸರ್ವ್ ಇನ್ ದ ಇಂಪ್ಯೂಡ್ ಆರ್ಡರ್, my lord.
Yes, that's all. Whom he has executed in a
My lord, in favor of defendant number 11.
defendant number
11.
ಅವ್ರು ಬರ್ಲಿ ಅವರು ಬಂದು ನೋಟಿಸ್ ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್, my lord.
or issue notice. Who is given a agreement of sale?
All the defendants number 1 to 8 they have executed.
Yes. Defendants 1 to 8 are directed not to execute that sale deed in favor of defendant number 11.
Already executed sale deed.
Not to execute that sale deed in favor of respondent number 11. Defendant number 1 to 8, alla respondent number 1 to 8.
Respondent number 1 to 10, my lord. Sorry.
1 to 10 is directed not to execute sale deed in favor of respondent number 11 in respect of suit scheduled property till next date of hearing. When do you want?
First week or second week.
Yes.
That is a detailed objection.
Yes, 12.
Along with that.
ಈ ತರ ಹಾಕಲಿ. The respondent prays time to file an objection to that IA. ಆಮೇಲೆ ಈ ಆರ್ಡರ್ ಮಾಡಿ.
But taking advantage of the before RRT ಅದಂಗೆ ಹೋಗ್ತಾ ಇದೆ.
ಅದಕ್ಕೆ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ ಇಲ್ಲ.
That reason
ಸೇಲ್ ಡೀಡ್ ಒಂದ್ ಮಾಡಬೇಡಿ ಅಂತ
ಅಷ್ಟೇ. Taking advantage of the order, ಅಲ್ಲಿ ಬಂದು objection ಹಾಕ್ತಾರೆ.
That is also till next date of hearing. Next date of hearing you can get it much. Yes.
Nataraj G for appellant.
Yes.
For declaration notes and the injunction was filed upon. Notes, the plaintiff's contention of the plaintiff's notes is that.
You are a plaintiff or a defendant?
Plaintiff.
Plaintiff. Suit for
declaration and for the injunction.
Yes.
Notes, it's a condition of the plaintiff note that my father notes a purchase of property. Suit shall property is not being notes all agricultural lands. Notes in an auction purchase not being conducted by the revenue department. Notes way back on 16/1/1962. Notes possession notes was handed over notes on 3/9/1963. Of the notes of suit shall property. Right from the date notes of 1963 notes till 2009 notes revenues and interest notes stood in my name.
Yes.
in my father's name.
Hmm.
Then notes in the year 2015 notes of the demise of my father, notes when I want not to make a Bhauti Kada notes in my mother's name.
Hmm.
In the year 2016 note, then notes it was brought to my knowledge that there is a change in the revenue address in the favor of a dependents.
Yes.
Then notes I challenge notes revenue address notes in the year 2017 notes and the matter is still pending adjudication.
Yes.
Then notes on the contrary notes I find note this particular suit.
Yes.
Declare that notes by virtue of notes purchased by my father in the option purchase notes, I am the owner of the suitable properties.
Hmm.
And notes and also notes since they were creating interference notes, I thought for injunction.
Hmm.
Notes along with that notes since the revenue address stood in the name of a dependents, notes I find the application notes that not to eliminate the property of the party. The trial court notes of please to grant notes injunction,
Yes.
not to eliminate property notes temporary
Issue
injunction.
notice. Parties are directed not to alienate that suit scheduled property. Not to create third party interest in respect of suit scheduled property till next date of hearing.
Revinath R for appellant, Ramesh Kumar V.
Yes. Yes.
My application under 39-112 has been rejected.
You are
I have filed a suit for declaration, mandatory injunction and injunction. The suit scheduled properties have been purchased by me in the year 1975. In my sale deed, there is a mistake in survey number. It should be 128/1, where it has been mentioned as 128/2. The respondents 1 to 8 grandfather has been sold to my father.
what is
Now-
the boundary?
Boundaries are the same
Boundaries are same. Yes. Ultimately, boundary prevails.
for extent.
Yes.
When now the respondent 1 to 8 has sold the suit scheduled property to the different number 9, respondent number 9. The year 2022. Thereafter, I filed a suit for declaration and mandatory injunction for rectification of my sale deed. In my suit, the application came to be rejected.
Application for what?
For 39-112 and
39 and 2 for what?
39 not to interfere with the position of the suit scheduled property and not to alienate the suit scheduled property.
Are you in the position?
Yeah,
They
I'm in
have
the
sold
position.
that property.
I am in the position of the property, but I'll explain. I am in the position of the property. Where the defendant number 9, he didn't made an application based on his sale deed. He made an application before for Kodi Durastu. And he had filed an petition before this on for mandatory. That petition
Where is your sale deed?
my sale deed is of
1975.
year 1975.
Where is that?
Right.
What is the boundary in the sale deed?
The same boundary is there. From my say east as per the plain schedule itself, page number 52.
Where is your this thing? Sale deed?
Where I had purchased under 2 different sale deeds.
What is the extent?
19 guntas.
19 guntas. Boundary
I'll make the time. I'll produce the typed copy itself.
typed copy. We'll have it after vacation.
Let them only one, not to precipitate the matter till next date of hearing.
Why? It
When
is your suit. It is if it is precipitated, it is for you.
That he will be interfering with my position of the property.
Who?
But different number 9. I am seeking only against the different number 9.
What he is doing?
But he will interfere with my position of the property.
What is that? It is a vacant land or
A vacant land.
what he will do by interfering? Mr.
But where he had filed in based on his sale deed, based on sale deed of the year 2022, made an application for Kodi Durastu without making me as a party. The writ petition came to be allowed. As against that, I preferred a writ appeal. Writ appeal is pending before adjudication before the court. But this court granted me not to precipitate regarding respondent official to conduct the Kodi Durastu. That itself has been stated in my grounds itself.
There you have any order of by the division bench?
Yes. Not to precipitate against the officials is there, but not against the different number 9.
No, this is a vacant site. What he will do by interfering? You are not in that position. He is not in the position.
Madam, I am in the position of the property.
See, vacant site, Supreme Court said that only if they are putting up any construction, then otherwise nobody can.
These are the agricultural lands, madam.
What is that? Is there any crop?
No crop.
Then you tell me that what is
Not to
going to
precipitate
happen?
them till the next date, not to precipitate.
No, to granting an interim order, there should be some threat or apprehension. What is going to happen till next day?
He will interfere
If
with.
they are want to put up any construction, then I will ask whether they have any plan or not, how they have. If it is any agriculture land, crop is there, then I can protect. Nothing is there, vacant land. It is
Vacant
only
land
for
where-
council that
he's
that interim order has to
My
be there.
only apprehension is he's a powerful person in the locality. Based on
Take
that,
it that, what he will do it in that land, open land, you will take that mud or soil.
let me
Nothing.
protect my instinct. If I any adjust, I can move in the vacation photo.
Yes. Least this matter, at the request of council for the parties, urgent liberty is reserved to the parties to move before the vacation. You
Then
can't do anything.
respond 8 to 9 to notice.
Notice move ಹಾಕಿದ್ರೆ vacational notice ಇರುವಾಗ ತಕ್ಷಣ ಮತ್ತೆ ಅರ್ಜನ್ ಆಗುತ್ತೆ. You be very, advocate should be very sure in that, mister. In that ground itself, notice has not been.
Only that apprehension he will make
You can't move that also if it is notice is issued. Yes.
Where I had an order of the trial court, for the trial court, I had first this interim order was there.
Now you want to move in that vacation bench. If I want that interim order, I have to hear on merit. Otherwise, I have given a liberty.
Let me hear on the merits.
Yes. Now tell me that interim order, what is going to happen in that 1 week?
He will precipitate with my matter.
What precipitation? Tell me, mister. You have to tell that what he will do it.
He will make an.
If there is any building, we can say that not to demolish.
There is no building, it's an agricultural land.
Yes.
He will precipitate the matter, he will fix a boundary to my property that we will be with that property.
What
In respect of the 19 quotas of the land.
Yes, what is going to do, madam, your client during that?
Page 37 down.
Yes.
Page 37.
Yes.
Last 4 lines,
Yes.
last 5 lines. I have also observed, put your lordship, lay hands minutes.
Yes.
I have also observed earlier that in spite of death of their mother, which was taken place in the year 2002, plaintiffs did not make any of this September till 2023. They remained quiet for over 21 years before filing this. Therefore, case of entire events on the evidence about proof of the title and question. Therefore, as of now, plaintiffs did not to any prima facie.
Oh, you forget about that survey number.
The plaintiff's father had remained silent for over 27 years.
This
From
fact,
the date of
Right? Yes. No, this is only regarding that survey number.
yes,
Boundary, is there any boundary different? No, Iga, sale deed in the year 1975, what he has claimed that boundary, is it the same boundary which your client has been purchased?
The extent is different now. The claiming only 19 plus. That 19 the entire extent and then see here and there manors. The topography changes. That's where it requires some, even for lordships to pass an order, that way also. It's a holistic of all these documents with you. And when
No, it is not that. Allah, what is that extent he has purchased? ನಿಮ್ದು ಎಷ್ಟಿದೆ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ?
ನಮ್ದು ಜಾಸ್ತಿ ಇದೆ.
ಎಷ್ಟು?
ಇಲ್ಲ same.
ನಮ್ದು
Same boundary. Same boundary. How can that say once it has been sold to him, your client
Their
purchased that?
vendors, it's at
Forget about that, whatever may be that say in survey number, boundary is the same.
1975.
No, you see that finding of the trial court is only on the ground that he has not seek for a rectification in respect of the boundary. Even otherwise,
survey number, not the boundary.
the survey number, yes.
Boundaries prevail over extent or survey number. That's it. My respect submission to your lordship is from 1970 till this day. All the revenue records have been in my name, whatever it be. Now, can they just based on that alone, can they do something today in an application under order 13-182 is something. There they have to establish that the survey number, the numbers are entirely different, these numbers are entirely different. That's what has to be proved. It requires evidence and I have filed a detailed return statement.
No, that
Here it cannot. I will just kindly pass it over and establish before your lordship all the things because return statement, I have filed a detailed return statement.
no one will argue that I will hear. Yes.
We have established clearly, Manas. We have clearly mentioned how 120.
Don't do till first week of January. It's a vacant site.
Because they have sought for, can we see the application they have filed with the lordship?
No, I'm not granting what they have sought. I said that whatever there, if you are in the possession, you maintain it status quo till you are filing an objection. I'm not saying that you have to dispose from them.
Their IA is not to alienate ಅಂತ ಅವ್ರು ಇಲ್ಲಿ ಕೇಳಿರೋದು.
Is it?
Not to alienate, not to interpret, both are.
ಅಲ್ಲ, ನಾವು ಗಮನಿಸ್ಬೋದು. ನಿಮಿಷ, ನಾನು ಈ
Where is that
maybe I
topic?
cannot correct me. Correct me. Can we see, my lords? There are application before the lordships.
Page number 103.
I to don't create the third party interest till next week.
That may be, ಅಲ್ಲ ಅದನ್ನ January first week ಗೆ ಅಂತ hearing ಕೊಡ್ಬೋದು. Till then ಅಂತ.
Aste.
ನಾನು ಕನ್ಸಿಡರ್ ಮಾಡ್ದೆ ಅಂತ ಬೇಡ.
Consider my order. Yes. Heard.
ಕೋಟಿನೇ ಆಗಿಲ್ಲ. ಕೋಟಿ ಆಗಿದ್ರೆ ಯಾರು ಏನು ಮಾಡಲ್ಲ. ಕೋಟಿಗೆ ಅಲ್ಲಿ ನಾವು ಇವ್ರು ಏನು ನಮ್ಗೆ ಆರ್ಡರ್ ಆಗಿತ್ತು ಅದನ್ನ ನಾವು ತಗೊಂಡೋಗಿ ಸ್ಟೇ ಆಗಿದೆ. ಅಫಿಷಿಯಲ್ಸ್ ಏನು ಮಾಡಬಾರ್ದು ಮಾಡಿದ್ರೆ ಅಫಿಷಿಯಲ್ಸ್ ಕೋಡಿನೂ ಮಾಡಲ್ಲ. ಕೋಡಿ ಮಾಡ್ತೀರಾ, ಈ ಸ್ಕೆಚ್ ಆಗ್ತೀರಾ, ಯಾರಿಗೂ ಸೇಲ್ ಮಾಡಕ್ ಹೋಗಲ್ಲ.
ನನಗೂ ಗೊತ್ತು. I already said it is all for the satisfaction of the council. That's all. Yes. Now your party is also happy that anyhow I am not going to alienate. Court has granted an order. Yes.
50 years after that I have
Yes. Heard. Issue notice. Parties are directed not to create third party interest in respect of suit scheduled property till next date of hearing. Yes.
Both are.
Yeah.
Admin for both.
Fourth, when do you want?
Both are.
Fourth. Yes. Leave this matter on fourth. Yes.
Record records may be secured.
Records beka?
Service ಬೇಕಾಗಿದೆ.
That you can produce that. Yake, I am not requesting any records because trial may be go on. We don't know when it will be decided. Most of the cases has been become infructuous because the trial has completed. Therefore, that let the trial go. You produce that filing in this thing.
I'll put.
Yes.
Number 59, with the short mark for appellant.
Suit for recovery was filed. In that suit, there was an order of attachment.
Yes.
The learned judge rejects the order of attachment.
Yes.
The total amount is 2 crore 50 lakhs. There are checks that have been given for which the order
Court
of
is decreed for how much?
the attachment was for 2 crore 50 lakhs.
2 crores. Why that application for attachment is rejected?
But the learned judge comes to a very narrow conclusion.
Yes.
He says that I have not pleaded in my affidavit that I am going to be put if the decree is not granted, he will not be able to.
Who is that respondent is?
It's a shelter, it's a builder company.
Hmm.
It's a builder developer company.
Has they denied that payment?
But they have said that the checks have been manipulated, entries have been made.
But there is a degree. They have not challenged that degree.
But they are not challenged.
They have not.
Decree has been passed yet. It is still pending before the court now. It is pending since it is not for
It's a suit, in the suit it was. But
The
this
suit
is
you
what
have-
the learned judge says.
Suit for attachment before degree.
That's all.
That's what that you are claiming.
Don't sell the property, that's all.
Attachment. The document attachment in notice was issued, objections.
Then it is in a company. Why do you worry that they
But
will?
it's not a company.
Mr. Lordsman, kindly put the affidavit that are filed at para 35. All these properties are subject matter of charge of the bank, nationalized bank. How
Yes.
can there be an attachment and as a pair, I have intimated the attachments in respect of all these properties now.
Yes.
But there is no such objection
Please,
statement.
your Lordsman, kindly go to the objection date itself for credit has been
No, they have
35.
produced that State Bank of India, Mahindra, Kotendra.
All these properties are subject matter of charge of Bank of India.
Yes, you take notice. Yes. You are taking notice to both.
Please,
Yes.
take notice.
Let them not alienate the property.
That is your final order. We'll see. Yes.
My lord may have it on the reopening day.
Yes. Then I will not.
No,
Yes.
don't pass any.
Reach this matter. 2nd January. Yes.
Number 60, Rajendra S for appellate.
ಬೆಳ್ಳಿ ಕೇಬೇಟ್ ಮಿಲಾಡಿ ಫಿಲಿಪಿಂಗ್ ಇನ್ನೊಂದು ದಿನ ಹಾಕಿತ್ತು ಪವರ್ ಸೈಡ್ ಕಟ್ಟೆಡ್ ಬಿಲ್ ಮಾಡೋ ಮೇಲೆ ಅದು ರೇಟ್ ಅಂತ ಡಬ್ಲ್ಯೂ ಆಗ್ತಿದೆ ಇಲ್ಲಿ ರಿಓಪನ್ ಡೇ ಹಾಕಂಡ್ರೆ ಈಗ ಇವ್ರು ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಯ್ತು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ
Being fair itself is now being casting me.
No, what is that going to happen by 1 week?
I am seeking for injunction.
No, that injunction can be granted if something will happen to.
They are selling.
They are going to, yes.
they have executed the registered settlement deed in favor of the
ಆಯ್ತ್ರಿ, ಈಗ ಕೋರ್ಟ್ ಮುಂದೆ ಕೇಸ್ ಇದೆ, ನೀವು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಟೈಮ್ ಕೇಳ್ತಿಲ್ಲ, ಕೇಬೇಟ್ ಹಾಕಿದ್ದೆ.
ಆಯ್ತು, that is also asking one other method of asking. It is an, see, seeking a time is an art of advocacy. No, that has to be there. You have to convince the court. See, when you are asking the time, yes, I will grant, but taking that advantage, don't that.
Because in this case,
No, that's counsel. I am not saying that you are making any false condition. It is true, but taking that adjournment, if you make anything in that in between, then its purpose of filing an appeal will frustrate. Therefore, either you have to instruct the parties that this is, I have taken a time not to do anything. Otherwise, if you are ready, I will hear. That is how that. Otherwise, there is no interim order. In between that, if that alienation, everything is taken, then it will appeal become infrastructure. Then the purpose of approaching the court will defeat. ಅಲ್ಲ ಸರಿ, ಇವತ್ತಿನವರೆಗೂ ನೀವೇನ್ ಮಾಡಿ?
ನಮ್ಮ ಸ್ವಲ್ಪ ಪ್ರಾಪರ್ಟಿ ಇದು, ಅವರು ಅದನ್ನ ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ.
No, wait for two weeks. Don't do anything.
ಇಲ್ಲಿವರೆಗೆ 2010 ಇಂದ ಇಲ್ಲಿವರೆಗೆ ಏನೂ ಆಗಿಲ್ಲ, ಈಗ ಅವ್ರು ಆಗ್ಬಿಟ್ಟು ಸಡನ್ ಆಗಿದೆ. That is the consideration of the case.
That means to show that your party wants to alienate within 2 weeks.
ನಾನು ಇಲ್ಲ, ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ನಾವು ಹಾಕಿದೀವಿ, ಯಾವ್ದಾದ್ರು ಮಾರಿದೀವಿ, ಯಾವ್ದಾದ್ರು ಮಾರಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅದನ್ನು ನಾನು ಆಗಿಲ್ಲ.
ನೀವು ಮಾರಿದ್ಗಿರಿದ್ರನ್ನೆಲ್ಲ will not. I can't do anything if it is already happened. In 2 weeks, next date of hearing, don't alienate that property. Otherwise, filing that appeal, court without hearing adjournment, parties to alienate, then purpose of approaching the court will defeat. ಎರಡು ದಿನ ಸಾಕು ಬೆಂಗಳೂರಲ್ಲಿ ಪಾರ್ಟಿಗಳು ಥರ್ಡ್ ಹ್ಯಾಂಡ್ ಚೇಂಜ್ ಆಗ್ಬಿಡ್ತದೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಡೇಟ್ ನಾವು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
No, if you are ready, I will hear that.
ನಾವು ಮಾಡ್ಬಿಟ್ಟಿರೋ ಪ್ರಾಪರ್ಟಿ ಏನ್ ಪಾರ್ಟಿಷನ್ ಕೇಳ್ತಿದ್ದಾರೆ, ದಟ್ ಇಸ್ ದಿ ಇಶ್ಯೂ. ಅದು ಬರದೆ ಅದಕ್ಕೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಕನ್ಸಿಡರ್ ದಿಸ್ ಥಿಂಗ್. ನನಗೆ ಇಮಿಡಿಯೇಟ್ ರಿಓಪನಿಂಗ್ ಡೇ ಯಾಕಂದ್ರೆ
No, even I will grant after 2 weeks after that vacation, but don't do anything. That's what that.
ನನಗೆ ಬಂದಿರೋ ಪ್ರಾಪರ್ಟಿಗಳು
ಮತ್ತೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ರಿ. Yes, give that file, Mr. This is not the way, Mr. Yes. Yes. Pass over. I don't know that whether I will be sick on 2:30 or not. Yes, pass over. Yes. Yes, pass over, Mr. Yes.
Serial number 1, Raju S for appellate.
Yes.
Office objection.
ಎರಡು ಮಾಡಿದರೆ ಒಂದು ಮಾಡಿಲ್ಲ.
Leave this matter. First week of January. A week's time is granted to complete the task.
Number 2, Padmavati for appellate.
Serial number 2 now.
Serial number 4.
Yes.
Order.
ಎರಡು ಮಾಡಿದರೆ ಒಂದು ಮಾಡಿ.
Which one they have not done? Seal affects to the color not tally with. Yes.
These may not be.
That is the only officer.
Insurance company name may not in the.
Yes.
What it is shown as.
In respect
the
of.
Insurance company, it is new the
In
assurance.
respect of office objection number 3, submission of counsel is accepted. Office objection is overruled. Learned counsel for the appellant has submitted that office objection 1 and 2 has complied. Office to verify. Yes. What is this, Mr.?
I am only challenging on the notes. Contributory negligence and quantum.
Yes.
The rate of interest notes is awarded 9%.
Or issue notice. Stay of judgment and award dated 6th additional district and session judge MACT Bangalore in MEC 782 of 2021, subject to deposit of 50% before.
50% is already deposited
Why?
before the tribunal. I am producing the proof of deposit.
Why you have deposited?
There is an execution note which is filed.
Yes.
285 of 2023.
says learned counsel heard the learned counsel for the appellant on IA number 2 of 2023. He has produced that memo enclosing that he has produced the memo stating that 50% of the award amount has already been deposited. Along with that, interest has been deposited before the trial court, before the tribunal. The memo dated 21/12/2023 is taken on record. Stay of so and so. Yes. 50% better.
Yes, Venkata Subbarao. Partially ಮಾಡಿದ್ದಾರೆ 6 sir. Partially ಮಾಡಿದ್ದಾರೆ partially ಮಾಡಿಲ್ಲ.
What are the office objection?
First one is with regard to limitation. What had happened that before the senior court, when senior civil judge court, the appeal was preferred. And the valuation was 12 lakhs. But the appeal is ordered to be returned to me, to be presented before the appropriate forum, which would be this honorable court, because value exceeds 10 lakhs. So therefore, my lord, on representation, my lord, the appeal is preferred.
No, that you have to state everything in that filing an
I
application.
have said, my lord, I have said in the
No.
memorandum of appeal.
IA has to be filed, and that you have to explain this. There is no excuse for this thing, filing an delay. Once that limitation has been crossed, you can file, but these are all that ground which is available for you to condonation of delay.
My lords would see,
No,
my lord,
without filing an
appeal
application.
is ordered to be returned. That's what I, my lord, intend to submit. My lord, if it is dismissed there and my lord, file it afresh, my lord, I'll have to make an application. When it is returned to be presented, it is as good as my lord, filing the appeal, my lord, before. this.
Written to be presented when?
My lord, the order is there, my lord. I have enclosed it, my lord, along with the appeal memo. Page 42, my lord, and 43. Office is directed to return the certified copies of the order sheet, plain written statement application. Memo impugned, which is filed along with the appeal to be counsel. Appeal dismissed is what is the order. Order was passed, my lord, on 15/11/2023. But within 30 days, my lord.
No, show me that any judgment saying that if it is returned with present proper code, application need not be filed. I don't know that because the law is that without filing an application, we can't entertain at all. Verify that, or we better file an application. I will permit it to move it in vacation bench. If there isn't. Yes, you want to after vacation or in the vacation bench?
My lords would observe, my lord, and meanwhile I'll have it filed and do the vacation.
Yes.
Insofar as valuation slip is concerned, that's one objection that may be taken on record. It is ready.
Yes. Learned counsel for appellant has filed memo.
Valuation slip, my lord,
In
that is
respect
also
of-
one of the objections.
Office objection regarding non-furnishing of valuation slip. The same is taken on record. In respect of non-compliance of other office objection, he prays 2 days time and he may be permitted to move before the vacation bench if need arises.
Serial number 8, H. Sarmati for appellant.
Yes. Madila. Yes, learned counsel for the appellant submits that office objection has complied. Third, issue notice, stay of delay stay of order dated 1st August 2023 passed by MECT Bangalore in MEC 6439 of 2018, subject to deposit of entire compensation amount with interest before this court within 4 weeks.
Serial number 12, K.M. Subbareddy for appellant. M. Sundararama.
When do you want?
Can be had immediately after.
Second, third, leave this matter on 3rd January.
Because the objection, we'll have to apply.
I
As
let
I
him.
pointed out, because all wrong documents have been filed.
You have an opportunity to argue before that the bench, the other roster bench. Yes. Yes. I think it is Justice Hiramat, and that has been followed by Justice Gurrajan, single bench. Justice. No, Gurrajan, ಇನ್ನೊಂದು ಯಾವುದೋ ಒಂದು division bench. Anyhow, that we will have it on 3rd.
I will look at.
Yes, 3rd.
Great.
24, Narasimhaya K. for appellant. S. D. Narasimha Prasad.
20. ಏನಕ್ಕೆ ಅವ್ರು ಯಾರು ಇವರು ಅಡ್ವೊಕೇಟ್ ಏನೋ ಕೇಳಿ ಹೇಳ್ತೀನಿ ಅದ್ರಲ್ಲಿ ವೆರಿ ಪಾಸ್ ಅವ್ರು ಕರ್ಸರಿ ಇನ್ಯಾವ್ದು ಮ್ಯಾಟ್ರ್ ಇಲ್ಲಲ್ಲ ಟೋಟಲ್ ಅಷ್ಟೇ.
Serial number 26, Raghavendra for appellant, B.D. Chandrasekhar.
Yes.
Got the
Why it is passed over?
sanction.
Plan sanction.
Please. LP number is there. I paid 18,22,000.
When it is sanctioned? When that order has been passed?
Building license at page number 3.
Date August 2023, no? Yes, on 2nd August 2020.
Second. Building plan also produced.
Yes, what is this? Why it has? Who is appearing for other side?
Area and
B.D. Chandrasekhar.
Where is the other side?
I have filed a memo before the trial court will not seeking that I will not claim equity. Para 13 my memo is being considered, but the learned judge says I may claim, I may demand cost of construction of last time. I already filed a memo of G, annexure G. I filed a memo stating that I am not going to claim any equity. Moreover, the suit itself is not maintainable for a simple reason that release date has been done. It is not been challenged till date. 2005 will release date.
Where is the other side? He was there.
I also called him.
What he said? Yes. What is that the suit for?
Suit for partition. There are totally 19 items. Schedule A and Schedule K are the two items. I am doing some developmental work. Schedule A is I am only using for storage. Adakine I am sanctioned tagondilla. Schedule K is concerned 7.5 gunta. Adralli I am raising a construction for which I have obtained all the necessary.
What is that defense of that this thing? You are a defendant or an
Defendant has filed an application. In that application, you kindly see.
No, that you are in a defendant number 2 to 4. Their agent, anybody hereby restrained from changing the nature of the suit schedule A and K property by you are the defendant.
I am the defendant. Plaintiff has already executed.
Any manner over the suit schedule. You are now that license is only for the K.
Yes.
Yes. Any construction in the suit schedule K property is subject to the result of that appeal.
Yes.
Yes, till next date of hearing. Where is that other side? Heard. You should notice. Okay, waiter or yaar gobrigena?
Yes, already.
Yes, K waiter is directed to take notice for respondent. Yes, pass over. Let us see one.
No.
I think I don't have any matter, but 2:30 I will not sit. Before that, another matter pass over is there. If he comes, we will.
Aye.
Yes.
Number 60.
Yeah.
Attendance.
Yellow bro. Where is? It banta. Mood matter. Mood matter. Yes. Yes, Mr. Ranap, what is?
Matter. Serial number 1, this is Ramarao.
Notice was ordered in this matter, and since there was no execution filed at that point in time, stay was not granted. Now, Milas, there is a warrant that has been issued in the execution proceedings. Hence, Milas, a request for stay to be granted.
No, that on what ground you are challenging?
Negligent.
You deposit 50%.
I'll deposit 50%.
Or issue notice. Stay of judgment and award dated 29th April 2023, passed by Second Additional Senior Civil Judge, MACT, Chikmagalur, subject to applying deposit 50% of that award amount with interest before the tribunal.
Before this court.
Before this court within 4 weeks from today. Yes.
Approve matter, page number 1, serial number 22, Shivakumarappa TC for appellant. Officer.
Correction ಮಾಡಿ.
20 lakhs, sir. ಮಾಡಿದಾರಾ? Yes, what is this, Mr.
Appellant number, whose name is, share with correction. Correction
ಮಾಡಿದಾರೆ. What is this? It's a climate appeal.
Climate of enhancement, R1 dispensation memo file.
Notice
R2,
or notice memo filed for dispensation of notice to R1 is dispensed. Issue emergent notice to R2. First time notice ಹೋಗ್ಬೇಕು.
Please.
Yes.
24, Narasimhaya K for appellant, SB Narasimha Prasad.
ಇದುವರೆಗೆ ಬರ್ಬೇಕು ಮತ್ತೆ. Password. Yes, where is your opponent? Yes, 2:30. I will back at 2:30. Now I finished it. Right. Yours also 2:30. Sir. Let us see. One more opportunity. Yeah. ಮುಗಿತಾ ಸರ್? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮುಗಿತಾ? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮುಗಿತಾ?
Next matter 23. Compliance ಕೊಡ್ತಾರೆ. CPC ಮಾಡಿದ್ದು ಮುಗಿಸಿಬೇಕು. ನೋಟಿಸ್ ನೋಟಿಸ್ ಯಾಕೆ ನಾನು ಬರಲೇ ಇಲ್ಲ, ಎಲ್ಲ ನಾನೇ ಹೇಳಿದ್ದೆ. ನೋಟಿಸ್ ಮೂರು ನಂದಪ್ಪ. Pastor matter, list number 1. Serial number 24, Narsimaya K for appellant, SP Narsimha Prasad.
Yes.
As far as 11 hectares of land is concerned, my client has already entered into an agreement. The total extent of land is 1 acre 11 hectares.
1 acre?
1 acre 11 hectares. To which in respect of 11 hectares, he has already entered into an agreement. The remaining 1 acre, if there is a direction to dispose of this in a period of 6 months, I have no objection, it can be.
Your Lordship, the appellant was purchased and gifted to sister, appellant. And again, the mother, Shanta Lakshmi gifted to daughter. Again, so sold during the pendency of the period to respondent 2 and 3. Again, they sold during the pendency of the period, respondent 4. I have made a party as a respondent 4 in the amended plaint is there. So now he is the aged about 79 years, senior citizen. So as per Act, 2006 and 7 Act came into.
No, whatever you have done is done.
Before Act, we can reclaim the property.
I am passing an order today not to create any third party interest. not to alienate that.
In respect of 1 acre, your lordship may kindly see.
No, that
Where-
another half an acre, if you are
If there
already
is any
done.
semblance of right in so far, in favor of the plaintiff or the appellant, your lordship may proceed to pass orders. Your lordship may kindly appreciate. He, on 13/10/1999, he purchases the property. First appellant purchases the property.
Hmm.
On 29/7/2004,
Hmm.
he gives it to his sister
Hmm.
by name Shanta Lakshmi.
Hmm.
And this Shanta Lakshmi in turn gives it to her daughter
Hmm.
on 28/11/2008.
Hmm.
To this document, appellant number 1 is a signatory, he is a witness. Now he says that the property which I had given it to my sister was only to look after me, and there was I had only created a life interest. And in respect of this sale deed, when gift deed executed in favor.
See, 1 acre, 1.5 acres. If half acre is concerned, is already alienated. That is subject to the result of the suit.
Only 1 acre, 10 guntas, sir.
1 acre, 11 guntas.
1
10
acre,
guntas.
11 guntas. 11 guntas, he is already alienated. It is subject to the result of the suit. In 1 acre, I will direct him to not to alienate till disposal of the suit.
1 acre, 10 guntas.
10 guntas ಗೆ ಅವರು ಆಲ್ರೆಡಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Maridu is comes under trial has to decide.
ಅದೇ. That is subject to the result of the suit. In respect of 1 acre is concerned, you should not alienate or create till disposal of the suit. I can dispose of this appeal.
Suit is of the year 2021. Within 6 months.
Your lordship, I have given enactment. So before 2006, so reclaim the property. As per that, trial has to be conducted and decide. And also, if court may give direction to short-term aged person.
I will direct to dispose of within 8 months.
8 months.
Yes, dispose Martin.
Okay.
Yes. This appeal is filed by plaintiff challenging order dated 15 July 2023 passed by Senior Civil Judge Devanalli.
Survey number 14/3.
OS number 1406 of
14/3.
2022. Whereby IA number 2 filed by the plaintiff under order 39 rule 1 and 2 has been dismissed. The plaintiff has filed suit for declaration and injunction in respect of suit scheduled
I
property.
have filed
Survey number 14
court in the lower court. They are not filed. They are filed application only.
ನಿಂದೆ ಹೇಳಿರೋದ್ರಿ ಇರಿ ಆಮೇಲೆ ಕೇಳ್ಕೊಳ್ಳಿ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು ಅಂತ. ಎಸ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ಡ್ ಪ್ರಾಪರ್ಟಿ 1 acre 11 guntas. Along with that, plaintiff he has filed IA number 2 under order 39 rule 1 and 2 seeking injunction restraining the defendant number 4 from alienating, creating charge in respect of suit scheduled property, survey number 14/3 measuring 1 acre 11 guntas in Bommavara village. After service of summons, defendant number 4 appear through their counsel. After hearing the parties, trial court has dismissed that IA number 2 filed by the plaintiff under order 39 rule 1 and 2 by impugn order dated 15th July 2023. Being agreed by the same, the plaintiff has filed this appeal. So learned counsel appearing for defendant number 4 has submits that out of 1 acre 11 guntas, the defendant number 4 is already entered in a sale agreement in respect of 11 guntas.
11.
Under these circumstances and in the interest of justice, what is the stage of the suit?
There is no issues are framed.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ now the suit is set down for framing that issue.
Issues are framed. Evidence it is set
Set down for evidence. And that learned counsel for respondent has submitted so and so. Okay. Under these circumstances, the only relief can be granted here is that respondent number any alienation made by the respondent number 4 in respect of 11 guntas is concerned, it is subject to the result of the suit. He may be restrained to make alienation, or he may be restrained to not to create any third party interest in respect of remaining 1 acres in the suit scheduled property.
According to this, you should not interfere with my position.
Yes.
That may be clarified, my lord,
Yes.
because on the strength of this order, they would come and create problem.
Yes. Accordingly, the appeal is disposed of. In respect of 1 acre is concerned, parties are directed to maintain status quo.
Status quo.
In 1 acre in the suit scheduled property, 1 acre is concerned. Already out of 1 acre, 11 guntas. 11 guntas they have eliminated. 1 acre is in the possession of the defendant number 4.
The court has to decide.
ಅದನ್ನ ಹೇಳಿದ್ದು subject to the result ಅಂತ ಹೇಳಿದ್ದೀನಿ. Yes. If 1 acre is concerned, plaintiff is restrained from interfering into that possession of the defendant number 4, and defendant number 4 is directed not to create any third party interest in respect of 1 acre is concerned. The trial court is directed to dispose of the suit as expeditiously as possible, not later than 8 months from date of receipt of the copy of this order. Both the parties are directed to cooperate for early disposal.
Number 26, Raghavendra as per appellant, B.D. Chandrasekhar.
Yes. Yes. Yes, Mr. Now that he may be permitted to construct, but it is subject to the result of the suit. He has produced the plan.
Now, Mr. Pilot, I have also given the demo for not to.
Only in respect of
Schedule K.
Schedule K.
Schedule A is concerned, it's around 1 acre. And just using a small portion for storage of material.
No, see, is hereby restraining, changing the nature of the suit schedule A and K property. That I can say that only in respect of K, any changes is made subject to the result of the suit. Yes, Mr.
Stage of the suit. It is at the fag end of 2013 suit. It is for their evidence. If that stage is over, it will be for arguments and protest. One aspect of the matter. Second aspect is early in the morning they were argued on the basis of the release deed. The release deed is whether it is a valid document or not, whether it is validly and what circumstances it is executed is pending adjudication before the trial. Lordship may kindly appreciate so far as the equities are concerned. Page 21. Page 21.
Yes.
Equities as.
Yes.
Para 13. After 4 lines with this. Even though the dependent number 3 has filed a memo stating that he is not going to claim any equities, but he may demand the amount utilized for construction under the said circumstances. It is safe to stop the construction. Moreover, in the case it is at the stage of evidence of dependent numbers 2 or 2 to 4. That is appellants. If dependents conclude their evidence as early as possible, then this court will dispose the matter as early as possible. Lordship may kindly see the place which they have chosen to put up construction. Corner sites, Lordship may kindly see the photo. Earth excavation work is going on. They have chosen a corner portion abutting the main road. They have got it converted now. If they were to proceed with the construction, definitely they will claim that this portion we have converted.
No, he cannot, will made it, he has to file an affidavit before the court saying that he will not claim any equity.
I respect the Lordship is, when the suit is at the fag end of the proceedings, having sat down for 10 years, and when it came up for their evidence, instead of producing evidence, they wanted to start construction. Excavation work is going on.
Yes.
My respectful submission is, let there not be change, no change in the topography or nature of the property.
Yes.
At the back end of the partitions. That is my
Yes, who are the respondents?
respondents are
All are served or still?
Only for this.
Yes.
I am full respondent.
Yes. You have to file an affidavit before the trial court that you will not claim any equity.
I also made that submission before the trial court.
Yes, because now that plan has been sanctioned,
Yes.
there is a limitation is there for construction. Within that time, he has to construct.
Already sent around.
They should have been aware about the pendency of the partitions. Partitions would pending ಇರುವಾಗ ನಾನು plan ತಗೊಂಡೆ ನಾನು license ತಗೊಂಡೆ.
You know, a person who is in possession in the property, he has invested so much.
No.
Somebody will go and make any litigation. See, he has to wait for suffer. Otherwise, in all cases in Bangalore, one after the other, they will make any litigation. Person invested.
He need not wait endlessly. It is his stage. Let him produce evidence. I will cross-examine. He will go for arguments.
Yes.
That is the fag end of the suit.
Yes.
At this juncture, if the nature of the property were to be changed,
It is already changed. He has made it.
he is big earth excavation for
Now that, yes, foundation now.
big
This
earth
place.
excavation for now.
Yes.
At the earliest point of time, I have approached them.
Yes.
At the end of their IA also, my lord, they only say that you need pay the equity ಅಷ್ಟೇ ಬೇರೆ ಏನು ಇಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ I cleared that by filing.
Yes, correct.
I am ready to file affidavit also.
The caveator is undertaken to appear for respondent. This appeal is filed by defendant number 2 and 4. 2 and 4, defendant number 3 and 4. Allah, 2, 3, 4, 2 to 4. Challenging order dated 15th December 2023, passed by First Additional City Civil and Session Judge, Bangalore, whereby IA number 7 filed by the plaintiff under Order 39, Rule 1 and 2 has been allowed. Plaintiff has filed suit for partition and separate position. Along with that, plaintiff has filed partition and separate position. Later, the plaintiff has filed IA number 7 under Order 39, Rule 1 and 2, seeking temporary injunction restraining the defendant number 2 to 4, claiming through them from changing the nature of the suit schedule A and K property by putting up the constructions of any manner over the suit scheduled A and K property. After hearing both the parties, trial court has allowed the IA restraining defendant number 2 to 4 from changing the nature of the suit scheduled A and K property by putting up construction of any manner over the suit scheduled A. Now that only a K.
But para 8 of their application, they admit that A is concerned only temporary shed. K is concerned.
No, now you are putting up construction only K. I will permit in K only because plan is also in K.
Yes, but the A method I'm using only for storage. That's my submission.
No, that is not that. Code his prior is only not to change. Why I have to grant any relief which is in his application?
They are undertaking that they don't want to claim equities. Let them file an affidavit.
That's what I said.
The effect that in the FDP proceedings, ultimately, allotment of shares, they should not sit up and say that I have developed this and this has
That is
been
not
allotted
that.
to
Not
my
to claim any equity means it includes everything, mister.
If such an affidavit is filed.
Yes. Well, being agreed by the same, the plaintiff has filed this appeal. So and so learned counsel appearing for the defendant has filed this. So and so learned counsel appearing for the defendant number 2 to 4 has submitted that they have already obtained necessary permission from competent authority for putting up in a construction in scheduled K property, to scheduled K property, and he submitted that even they have filed in a memo before the trial court that in case if they fail in the suit, they will not claim any equity. And the suit is also now set down for
Defense evidence.
defendant evidence. Under these circumstances, I pass following order. The order dated so and so passed by the trial court is modified to that effect that defendant number 2 to 4 are permitted to put up the construction in suit schedule K property in accordance with law without claiming any equity, and also directed to file an affidavit before the trial court within 2 weeks from today, giving an undertaking that in case if they file, they will not claim any equity. With that observation, the above appeal is disposed of. The trial court is directed to dispose of this appeal within. Now that evidence, another 6 months, it can be closed within 6 months from date of receipt of the copy of this order. Both the parties are directed to cooperate for early disposal. Yes.
This objection. Discrepancy.
Yes, office objection is overruled. And list put it. List. Yes.
Serial number 60, Rajendra S for appellant.
Yes. 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 Learned counsel for the respondents are directed. Defendant number. What is that undertaking? I said to you.
They will not alienate any of the
Yes.
property.
Yes. You will undertake to appear for all respondents. Evator, so and so counsel is undertaken.
Event ಇಲ್ಲ ಅವ್ರೇನೋ ಆಗ್ಲಿ ಅವ್ರ ರಿಪಿಟೇಷನ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಬಟ್
So and so is undertake to appear for respondent number 1 to 3. The respondents learned counsel raise time to file an objection. Please this matter in first week of January till next date of hearing. The respondents are directed not to create any third party interest in respect of suit scheduled property. 21. 4th.
ಸೆಕೆಂಡ್ ವೀಕ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಡೇ ಹಾಕೊಂಡ್ರೆ ಸೋಮವಾರ 8ನೇ ತಾರೀಕು
8. Yes. Not undertaking, it is my order. Therefore, I have saved your. I said you asked for a time. Therefore, I directed. You will undertake. Then I will.
recorded.
Yes, I thoroughly.
Till next date of
Yes,
hearing.
he prays time. Wait, Mr. Ayupa. He prays time to file an objection, and he is also undertake that till next date of hearing, he will not create any third party interest in respect of suit scheduled property. Please this matter on 8th. Already till 8th ಅಂದ್ರೆ ಅದೇ ಆಗ್ತಾರೆ ಅವತ್ತು ನೀವು ಆ
real estate, defendants are doing the real estate. If they start real estate business, I have no any allocation.
I have not said that don't do real estate.
Also they are entitled for the profit. Plaintiff also entitled for profit.
I have not opened the file. I don't know anything. You said I recorded it. Whatever you said, but ditto I have recorded.
The undertaking will not carry on.
No, that
That has to be decided on 8th. Whether
I cannot put that. No, she were all regularly appearing. That is what that I can't say that.
They are taken untaken until it
I'll clear that you have to object. Naturally, definitely they will say that there is an undertaking, court may continue. You have to object. Therefore, counsels are there too.
That's the reason.
Yes.
ನಾವು ಕೂಡ
ಗಿರೀಶ್ ಫೈಲ್ ಸ್ವಲ್ಪ ಬೇಗ ತಂದ್ಕೊಡಿ, ಇವತ್ತೇ ಎಲ್ಲ ಸೈನ್ ಮಾಡಿಸ್ಬೇಕು. ಇವತ್ತು ಬೇಗ ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀನಿ.
ಬರಿಬೇಕಾ? ಹಾ.